Lokpal and Lokayuktas. Global scenario. Modern democratic states are characterized by a welfare orientation. Hence, the government has come to play an important role in the socio-economic development of a nation. This has resulted in the expansion of bureaucracy and the multiplication of administrative process, which in turn increased the administrative power and discretion enjoyed by the civil servants at different levels of the government. The abuse of this power and discretion by civil servants opens up scope for harassment, malpractices, maladministration and corruption. Such a situation gives rise to citizens' grievances against administration. 1. The success of democracy and the realization of socio-economic development depends on the extent to which the citizens' grievances are redressed. Therefore, the following institutional devices have been created in different parts of the world to deal with the redressal of these grievances. 1. The Ombudsman System. 2. The Administrative Courts System. 3. The Procurator System. The earliest democratic institution created in the world for the redressal of citizens' grievance is the Scandinavian institution of Ombudsman. Donald C. Roebuck, an international authority on the Ombudsman, calls it a uniquely appropriate institution for dealing with the average citizen's complaints about unfair administrative actions. The institution of Ombudsman was first created in Sweden in 1809. Ombud is a Swedish term and refers to a person who acts as the representative or spokesman of another person. According to Donald C. Roebuck, Ombudsman refers to an officer appointed by the legislature to handle complaints against administrative and judicial action. The Swedish Ombudsman deals with the citizens' grievances in the following matters: I. Abuse of administrative discretion, that is, misuse of official power and authority. 2. Maladministration, that is, inefficiency in achieving the targets. 3. Administrative corruption, that is, demanding bribery for doing things. 4. Nepotism, that is supporting one's own kith and kin in matters like providing employment. Discourtesy, that is, misbehavior of various kinds, for instance, use of abusive language. The Swedish Ombudsman is appointed by the Parliament for a term of 4 years. He can be removed only by the Parliament on ground of its loss of confidence in him. He submits his annual report to the Parliament and hence is also known as Parliamentary Ombudsman. But he is independent of the Parliament, legislature, as well as the executive and judiciary. The Ombudsman is a constitutional authority and enjoys the powers to supervise the compliance of laws and regulations by the public officials, and see that they discharge their duties properly. In other words, he keeps a watch over all public officials, civil, judicial and military, so that they function impartially, objectively and legally, that is, in accordance with the law. However, he has no power to reverse or quash a decision and has no direct control over administration or the courts. The Ombudsman can act either on the basis of a complaint received from the citizen against unfair administrative action or suo moto, i.e. on his own initiative. He can prosecute any erring official including the judges. However, he himself cannot inflict any punishment. He only reports the matter to the higher authorities for taking the necessary corrective action. In sum, the characteristics of the Swedish institution of Ombudsman are as follows. I. Independence of action from the executive. 2. Impartial and objective investigation of complaints. 3. Suo moto power to start investigations. 4. Uninterrupted access to all the files of administration. Right to report to the Parliament as opposed to the executive. The institution of Ombudsman is based on the doctrine of administrative accountability to legislature. 6. Wide publicity given to its working in press and other media. 7. Direct, simple, informal, cheap and speedy method of handling complaints from Sweden. The institution of Ombudsman spread to other Scandinavian countries: Finland, 1919, Denmark, 1955, and Norway, 1962. New Zealand is the first Commonwealth country in the world to have adopted the Ombudsman system in the form of a parliamentary commissioner for investigation in 1962. The United Kingdom adopted ombudsman-like institution called Parliamentary Commissioner for Administration in 1967. Since then, more than 40 counties of the world have adopted ombudsman-like institutions with different nomenclature and functions. The ombudsman in India is called Lokpal Lokayukta. Donald C. Roebuck says that the institution of ombudsman is a bulwark of democratic government against the tyranny of officialdom, while Gerald E. Caden described the ombudsman as institutionalized public conscience. Another unique institutional device created for the redressal of citizens' grievances against administrative authorities is the French system of administrative courts. Due to its success in France, the system has gradually spread to many other European and African countries like Belgium, Greece and Turkey. The socialist countries like the former USSR, now Russia, China, Poland, Hungary, Czechoslovakia and Romania have created their own institutional device for the redressal of citizens' grievances. It is called procurator system in these countries. It should be noted here that the office of the Procurator General is still functioning in Russia. He is appointed for a tenure of 7 years. Position in India. The existing legal and institutional framework to check corruption and redress citizens' grievances in India consists of the followings: 1. Public Servants Enquiries Act 1852. Indian Penal Code 1863. Special Police Establishment 1941-4. Delhi Police Establishment Act 1946-5. Prevention of Corruption Act 1988-6. Commissions of Inquiry Act 1952 against political leaders and eminent public men 7. All India Services Conduct Rules 1968-8. Central Civil Services Conduct Rules 1964-9. Railway Services Conduct Rules 1966-10. Vigilance organizations in ministries, departments, attached and subordinate offices and public undertakings 11. Central Bureau of Investigation 1963-12. Central Vigilance Commission 1964-13. State Vigilance Commissions 1964-14. Anti-Corruption Bureaus in States 15. Lokpal, Ombudsman, at the Center 16. Lokayukta, Ombudsman, in States 17. Divisional Vigilance Board 18. District Vigilance Officer 19. National Consumer Disputes Redressal Commission 20. National Commission for Scs 21. National Commission for Sts 22. Supreme Court and High Courts in States 23. Administrative Tribunals, Quasi-Judicial Bodies, 24. Directorate of Public Grievances in the Cabinet Secretariat, 1988-25. Parliament and its committees 26. File to Field program in some states like Kerala. In this innovative scheme, the administrator goes to the village area and hears public grievances and takes immediate action wherever possible. Lokpal, the Administrative Reforms Commission, ARC, of India, 1966-1970, recommended the setting up of 2 special authorities designated as Lokpal and Lokayukta for the redressal of citizens' grievances too. These institutions were to be set up on the pattern of the institution of Ombudsman in Scandinavian countries and the Parliamentary Commissioner for Investigation in New Zealand. The Lokpal would deal with complaints against ministers and secretaries at central and state levels, and the Lokayukta, one at the center and one in every state, would deal with complaints against other specified higher officials. The ARC kept the judiciary outside the purview of Lokpal and Lokayukta as in New Zealand. But, in Sweden the judiciary is within the purview of Ombudsman. According to the ARC, the Lokpal would be appointed by the President after consultation with the Chief Justice of India, the Speaker of Lok Sabha and the Chairman of the Rajya Sabha. The ARC also recommended that the institutions of Lokpal and Lokayukta should have the following features: 1. They should be demonstratively independent and impartial. 2. Their investigations and proceedings should be conducted in private and should be informal in character. 3. Their appointment should be, as far as possible, non-political. 4. Their status should compare with the highest judicial functionaries in the country. 5. They should deal with matters in the discretionary field involving acts of injustice, corruption or favoritism. 6. Their proceedings should not be subject to judicial interference. 7. They should have the maximum latitude and powers in obtaining information relevant to their duties. 8. They should not look forward to any benefit or pecuniary advantage from the executive government. The Government of India accepted the recommendations of ARC in this regard. So far, 10 official attempts have been made to bring about legislation on this subject. Bills were introduced in the Parliament in the following years.
1 in May
1968, by the Congress government headed by Indira Gandhi. 2 in April 1971, again by the Congress government headed by Indira Gandhi. 3 in July 1977, by the Janata government headed by Morarji Desai. 4 in August 1985, by the Congress government headed by Rajiv Gandhi. 5 in December 1989, by the National Front government headed by VP Singh.
6
in September 1996, by the United Front government headed by Deve Gowda. 7 in August 1998, by the BJP-led coalition government headed by A.B. Vajpayee. 8 in August 2001, by the NDA government headed by A.B. Vajpayee. 9 in August 2011, by the UPA government headed by Manmohan Singh. 10 in December 2011, by the UPA government headed by Manmohan Singh. The first 4 bills lapsed due to the dissolution of Lok Sabha, while the 5th one was withdrawn by the government. The 6th and 7th bills also lapsed due to the dissolution of the 11th and 12th Lok Sabha. Again, the 8th bill, 2001, lapsed due to the dissolution of the 13th Lok Sabha in 2004. The 9th bill, 2011, was withdrawn by the government. Lokpal and Lokayuktas Act, 2013. Background 3. In order to meet a long-standing demand to establish a mechanism for dealing complaints on corruption against certain public functionaries, including corruption at high places, the government had constituted a joint drafting committee on 8 April 2011, consisting of 5 nominee ministers from Government of India and 5 nominees of Shri Anna Hazare, including Shri Hazare himself, to prepare a draft of the Lokpal Bill. Based on the deliberations of the committee, and on the basis of inputs from chief ministers of states and political parties, a draft Lokpal Bill was prepared. The Cabinet at its meeting held on 28 July 2011 considered the draft Lokpal Bill, 2011 and upon approval by the Cabinet, the Lokpal Bill 2011 was introduced in Lok Sabha on 4 August 2011. The said bill was referred to the department. Related Parliamentary Standing Committee on Personnel, Public Grievances, Law and Justice on 8 August 2011 for examination and report. The department related Parliamentary Standing Committee, after extensive discussion with all the stakeholders, in its 48th report, made a number of recommendations suggesting major amendments in the bill both as regards the scope and content of the bill, including that necessary provisions be made, in the union legislation, for establishment of lokayuktas in the states, so as to provide leverage to the states where no such institution exists and to bring in uniformity in the laws relating to state lokayuktas which are already in existence in a number of states. The committee also recommended that Lokpal and Lokayuktas should be conferred constitutional status. Upon consideration of the recommendations of the Standing Committee, the government withdrew the Lokpal Bill, 2011 pending in the Lok Sabha and introduced a new comprehensive Lokpal and Lokayuktas Bill, 2011 in the Lok Sabha on 22 December 2011 to establish the institution of Lokpal at the centre and Lokayukta at the level of states. Also, keeping in mind the recommendations of the Standing Committee that the Lokpal and Lokayuktas may be made constitutional bodies, The government also introduced Constitution 116th Amendment Bill 2011 to provide for constitutional status to these bodies. These bills were taken up for consideration by the Lok Sabha on 27 December 2011. The Lokpal and Lokayuktas Bill 2011 was passed with certain amendments, whereas the Constitution 116th Amendment Bill 2011 could not be passed with the requisite majority. The Lokpal and Lokayuktas Bill 2011 was taken up for discussion and passing in the Rajya Sabha on 29 December 2011, but the discussion remained inconclusive. Subsequently, the Rajya Sabha adopted a motion on 21 May 2012 and referred the bill to a select committee of the Rajya Sabha for examination and report. The Select Committee of Rajya Sabha submitted its report to the Rajya Sabha on 23 November 2012. The recommendations of the Select Committee were examined and a proposal for moving official amendments to the bill as reported by the Select Committee was considered and approved by the Cabinet in its meeting held on 31 January 2013. The bill has been finally passed by Rajya Sabha with amendments on 17 December 2013 and the Lok Sabha has agreed to the amendments made by Rajya Sabha on 18 December 2013. The bill as passed by both houses has received the assent of the President on 1 January 2014. The Act has been brought into force with effect from 16 January 2014. Features. The salient features of the Lokpal and Lokayuktas Act 2013 are as follows. 3.1. It seeks to establish the institution of the Lokpal at the center and the Lokayukta at the level of the state, and thus seeks to provide a uniform vigilance and anti-corruption roadmap for the nation both at the center and at the states. The jurisdiction of Lokpal includes the Prime Minister, Ministers, Members of Parliament and Groups A, B, C and D officers and officials of the central government. 2. The Lokpal to consist of a chairperson with a maximum of 8 members, of which 50% shall be judicial members. 3. 50% of the members of the Lokpal shall come from amongst the Scs, the Sts, the OBCs, minorities and women. 4. The selection of the chairperson and the members of Lokpal shall be through a selection committee consisting of the Prime Minister, the Speaker of the Lok Sabha, the Leader of the Opposition in the Lok Sabha, the Chief Justice of India or a sitting Supreme Court judge nominated by the Chief Justice of India, and an eminent jurist to be nominated by the President of India on the basis of recommendations of the first 4 members of the selection committee. 5. A search committee will assist the selection committee in the process of selection. 50% of the members of the search committee shall also be from amongst the Scs, the Sts, the OBCs, minorities and women. 6. The Prime Minister has been brought under the purview of the Lokpal with subject matter exclusions and specific process for handling complaints against the Prime Minister. 7. Lokpal's jurisdiction will cover all categories of public servants, including Group A, Group B, Group C, and Group D officers and employees of government. On complaints referred to the CVC by the Lokpal, the CVC will send its report of preliminary enquiry in respect of Group A and Group B officers back to the Lokpal for further decision. With respect to categories of employees from Group C and Group D, the CVC will proceed further in exercise of its own powers under the CVC Act subject to reporting and review by the Lokpal. 8. The Lokpal will have the power of superintendence and direction over any investigating agency, including the CBI, for cases referred to them by the Lokpal. 9. A high-powered committee chaired by the Prime Minister will recommend the selection of the Director of CBI. 10. It incorporates provisions for attachment and confiscation of property of public servants acquired by corrupt means, even while the prosecution is pending. 11. It lays down clear timelines. For preliminary enquiry, it is 3 months extendable by 3 months. For investigation, it is 6 months which may be extended by 6 months at a time. For trial, it is 1 year extendable by 1 year, and to achieve this, special courts to be set up. 12. It enhances maximum punishment under the Prevention of Corruption Act from 7 years to 10 years. The minimum punishment under sections 7, 8, 9 and 12 of the Prevention of Corruption Act will now be 3 years, and the minimum punishment under Section 15, punishment for attempt, will now be 2 years. 13 institutions which are financed fully or partly by government are under the jurisdiction of Lokpal, but institutions aided by government are excluded. 14. It provides adequate protection for honest and upright public servants. 15. Lokpal conferred with power to grant sanction for prosecution of public servants in place of the government or competent authority. 16. It contains a number of provisions aimed at strengthening the CBI such as I. Setting up of a Directorate of Prosecution headed by a Director of Prosecution under the overall control of the Director of CBI. 2. Appointment of the Director of Prosecution on the recommendation of the CVC. 3. Maintenance of a panel of advocates by CBI other than government advocates with the consent of the Lokpal for handling Lokpal referred cases. 4. Transfer of officers of CBI investigating cases referred by Lokpal.
With the approval
of Lokpal, we, provision of adequate funds to CBI for investigating cases referred by Lokpal. 17. All entities receiving donations from foreign source in the context of the Foreign Contribution Regulation Act, FCRA, in excess of 10 rupees lakhs per year are brought under the jurisdiction of Lokpal. 18. It contains a mandate for setting up of the institution of Lokayukta through enactment of a law by the state legislature within a period of 365 days from the date of commencement of this act. Thus, the act provides freedom to the states to decide upon the contours of the Lokayukta mechanism in their respective states. Drawbacks. The following are the drawbacks, shortcomings, of the Lokpal and Lokayuktas Act, 20133B. 1. Lokpal cannot suo motu proceed against any public servant. 2. Emphasis on form of complaint rather than substance. 3. Heavy punishment for false and frivolous complaints against public servants may deter complaints being filed to Lokpal. 4. Anonymous complaints not allowed. Can't just make a complaint on plain paper and drop it in a box with supporting documents. 5. Legal assistance to public servant against whom complaint is filed. 6. Limitation period of 7 years to file complaints. 7. Very non-transparent procedure for dealing with complaints against the PM. Lokayuktas. Even much before the enactment of the Lokpal and Lokayuktas Act, 2013, itself, many states had already set up the institution of Lokayuktas. It must be noted here that the institution of Lokayukta was established first in Maharashtra in 1971. Although Odisha had passed the act in this regard in 1970, it came into force only in 1983. Till 2013, 21 states and 1 union territory, Delhi, have established the institution of Lokayuktas. The details in this regard are mentioned below in Table 59.1. Table 59.1 Establishment of Lokayukta in States, Chronological Order, SL No. States UTs created in, enacted in, 1. Odisha 1972. Maharashtra 1971-3. Rajasthan 1973-4. Bihar 1974-5. Uttar Pradesh 1975-6. Madhya Pradesh 1981-7. Andhra Pradesh 1983-8. Himachal Pradesh 1983-9. Karnataka 1985-10. Assam 1985-11. Gujarat 1986-12. Punjab 1995-13. Delhi 1995-14. Kerala 1999-15. Jharkhand 2001-16. Chhattisgarh 2002-17. Haryana 2002-18. Uttarakhand 2002-19. Jammu and Kashmir 3C 2002-20. West Bengal 2003. 21 Tripura 2008-22. Goa 2011. The various aspects of the institution of Lokayukta, structural variations. The structure of the Lokayukta is not same in all the states. Some states like Rajasthan, Karnataka, Andhra Pradesh and Maharashtra have created the Lokayukta as well as Upalokayukta, while some others like Bihar, Uttar Pradesh and Himachal Pradesh have created only the Lokayukta. There are still other states like Punjab and Orissa that have designated officials as Lokpal. This pattern was not suggested by the ARC in the states. Appointment: the Lokayukta and Upalokayukta are appointed by the governor of the state. While appointing, the governor in most of the states consults a. the Chief Justice of the State High Court, and b. the Leader of Opposition in the State Legislative Assembly. 4. Qualifications: judicial qualifications are prescribed for the Lokayukta in the states of Uttar Pradesh, Himachal Pradesh, Andhra Pradesh, Gujarat, Orissa, Karnataka and Assam. But no specific qualifications are prescribed in the states of Bihar, Maharashtra and Rajasthan. Table 59.2 Lokpal and Lokayuktas Act, 2013, at a glance. Section No. Subject Matter Preliminary 1. Short title: Extent, Application and Commencement Definitions.
2 definitions:
Establishment of Lokpal. 3. Establishment of Lokpal. 4. Appointment of chairperson and members on recommendations of selection committee. 5. Filling of vacancies of chairperson or members. 6. Term of office of chairperson and members. 7. Salary, allowances and other conditions of service of chairperson and members. 8. Restriction on employment by chairperson and members after ceasing to hold office. 9. Member to act as chairperson or to discharge his function in certain circumstances. 10. Secretary, other officers and staff of Lokpal Inquiry Wing. 11. Inquiry Wing Prosecution Wing. 12. Prosecution Wing expenses of Lokpal to be charged on Consolidated Fund of India. 13. Expenses of Lokpal to be charged on Consolidated Fund of India jurisdiction in respect of inquiry. 14. Jurisdiction of Lokpal to include Prime Minister, Ministers, Members of Parliament, Group A, B, C and D officers and officials of central government. 15. Matters pending before any court or committee or authority. 4.
Inquiry not to be affected.
16. Constitution of benches of Lokpal. 17. Distribution of business amongst benches. 18.
Power
Power
of
of chairperson
chairperson
to transfer cases. 19. Decision to be by majority procedure in respect of preliminary inquiry and investigation. 20. Provisions relating to complaints and preliminary inquiry and investigation. 21. Persons likely to be prejudicially affected to be heard. 22. Lokpal may require any public servant or any other person to furnish information, etc. 23. Power of Lokpal to grant sanction for initiating prosecution. 24. Action on investigation against public servant being Prime Minister, Ministers or Members of Parliament. Powers of Lokpal. 25. Supervisory powers of Lokpal. 26. 27. Search and seizure Lokpal to have powers of civil court in certain cases. 28. Power of Lokpal to utilize services of officers of central or state government. 29. Provisional attachment of assets. 30. Conformation of attachment of assets. 31. Confiscation of assets, proceeds, receipts and benefits arisen or procured by means of corruption in special circumstances. Power of Lokpal to recommend transfer or suspension of public.
32.
32. Servant connected with allegation of corruption. 33. Power of Lokpal to give directions to prevent destruction of records during preliminary inquiry. 34. Power to delegate special courts. 35. Special courts to be constituted by central government. 36. Letter of request to a contracting state in certain cases. Complaints against chairperson, members and officials of Lokpal. 37. Removal and suspension of chairperson and members of Lokpal. 38. Complaints against officials of Lokpal. Assessment of loss and recovery thereof by special court. 39. Assessment of loss and recovery thereof by special court. Finance, Accounts and Audit. 40. Budget. 41. Grants by central government. 42. Annual statement of accounts. 43. Furnishing of returns, etc. to central government. Declaration of assets. 44. Declaration of assets. 45. Presumption as to acquisition of assets by corrupt means in certain cases. Offences and penalties. 46. Prosecution for false complaint and payment of compensation, etc. to public servant.
47 false complaint
made by society or association of persons or trust. Miscellaneous. 48 reports of Lokpal. 49 Lokpal to function as appellate authority for appeals arising out of any other law for the time being in force. 50 protection of action taken in good faith by any public servant. 51 protection of action taken in good faith by others. 52 members, officers and employees of Lokpal to be public servants. 53 limitation to apply in certain cases. 54 bar of jurisdiction. 55 legal assistance. 56 Act 2 have overriding effect. 57 provisions of this act to be in addition of other laws. 58 amendment of certain enactments. 59 power to make rules. 60 power of Lokpal to make regulations. 61 laying of rules
and
and
regulations.
regulations. 62 power to remove difficulties. Establishment of the Lokayukta. 63 establishment of the Lokayukta schedule of the act. Amendment to certain enactments. Part I amendment to the Commissions of Inquiry Act 1952. Part 2 amendments to the Delhi Special Police Establishment Act 1946.
Part 3
amendments to the Prevention of Corruption Act 1988. Part 4 amendment to the Code of Criminal Procedure 1973. Part V amendments to the Central Vigilance Commission Act 2003. Tenure in most of the states. The term of office fixed for Lokayukta is of 5 years duration or 65 years of age, whichever is earlier. He is not eligible for reappointment for a second term. Jurisdiction. There is no uniformity regarding the jurisdiction of Lokayukta in all the states. The following points can be noted in this regard. The Chief Minister is included within the jurisdiction of Lokayukta in the states of Himachal Pradesh, Andhra Pradesh, Madhya Pradesh and Gujarat, while he is excluded from the purview of Lokayukta in the states of Maharashtra, Uttar Pradesh, Rajasthan, Bihar and Orissa. B. Ministers and higher civil servants are included in the purview of Lokayukta in almost all the states. Maharashtra has also included former ministers and civil servants. C. Members of state legislatures are included in the purview of Lokayukta in the states of Andhra Pradesh, Himachal Pradesh, Gujarat, Uttar Pradesh and Assam. D. The authorities of the local bodies, corporations, companies and societies are included in the jurisdiction of the Lokayukta in most of the states. Investigations. In most of the states, the Lokayukta can initiate investigations either on the basis of a complaint received from the citizen against unfair administrative action or suo moto. But he does not enjoy the power to start investigations on his own initiative, suo moto, in the states of Uttar Pradesh, Himachal Pradesh and Assam.
Scope of cases
covered. The Lokayukta can consider the cases of grievances, as well as allegations, in the states of Maharashtra, Uttar Pradesh, Assam, Bihar and Karnataka. But, in Himachal Pradesh, Andhra Pradesh, Rajasthan and Gujarat, the job of Lokayuktas is confined to investigating allegations, corruption, and not grievances, maladministration. Other features. 1. The Lokayukta presents, annually, to the governor of the state a consolidated report on his performance. The governor places this report along with an explanatory memorandum before the state legislature. The Lokayukta is responsible to the state legislature. 2. He takes the help of the state investigating agencies for conducting inquiries. 3. He can call for relevant files and documents from the state government departments. 4. The recommendations made by the Lokayukta are only advisory and not binding on the state government. Notes and references. 1. According to the Chambers Dictionary, grievance means a ground of complaint, a condition felt to be oppressive or wrongful. 2. The ARC headed by Morarji Desai submitted a special interim report on the problems of redressal of citizens' grievances in 1966. 3. Annual Report 2015 to 2016, Ministry of Personnel, Government of India, P.101-102. 3. A Press Information Bureau, Government of India, 23rd December 2013. 3b Taxman's Guide to Lokpal and Lokayuktas Act 2013, pp.I9 to I-11. 3c In Jammu and Kashmir, the institution is known as State Accountability Commission, SAC. 4 But, In Andhra Pradesh, the leader of the opposition in the state legislative assembly is not required to be consulted in this regard. In Karnataka, on the other hand, the chairman of the state legislative council, the speaker of the state legislative assembly and the leader of opposition in the state legislative council are also required to be consulted on this matter. Part 9 Other Constitutional Dimensions 60. Cooperative Societies 61. Official Language 62. Public Services 63. Tribunals 64. Rights and Liabilities of the Government 65. Authoritative Text of the Constitution in Hindi Language 66. Special Provisions relating to certain classes.
Cooperative
Societies. The 97th Constitutional Amendment Act of 2011 gave a constitutional status and protection to cooperative societies. In this context, it made the following three changes in the Constitution. 1. It made the right to form cooperative societies a fundamental right, Article 191. 2. It introduced a new directive principle of state policy on promotion of cooperative societies, Article 43b2. 3. It added a new Part 9b in the Constitution which is entitled, The Cooperative Societies, Articles 243zh to 243zt. Constitutional Provisions. Part 9b of the Constitution contains the following provisions with respect to the cooperative societies. Incorporation of cooperative societies. The state legislature may make provisions for the incorporation, regulation and winding up of cooperative societies based on the principles of voluntary formation, democratic member control, member economic participation and autonomous functioning. Number and term of members of board and its office bearers. The board shall consist of such number of directors as may be provided by the state legislature. 3. But the maximum number of directors of a cooperative society
shall not exceed
21. The state legislature shall provide for the reservation of 1 seat for the scheduled castes or the scheduled tribes and 2 seats for women on the board of every cooperative society having members from such a category of persons. The term of office of elected members of the board and its office bearers shall be 5 years from the date of election. 4. The state legislature shall make provisions for co-option of persons having experience in the field of banking, management, finance or specialization in any other related field, as members of the board. But the number of such co-opted members shall not exceed 2, in addition to 21 directors. Further, the co-opted members shall not have the right to vote in any election of the cooperative society or be eligible to be elected as office bearers of the board. The functional directors of a cooperative society shall also be the members of the board, and such members shall be excluded for the purpose of counting the total number of directors, that is, 21. Election of members of board. The election of a board shall be conducted before the expiry of the term of the board so as to ensure that the newly elected members assume office immediately on the expiry of the term of the office of members of the outgoing board. The superintendence, direction and control of the preparation of electoral rolls and the conduct of elections to a cooperative society shall vest in such body, as may be provided by the state legislature. Supersession and suspension of board and interim management. No board shall be superseded or kept under suspension for a period exceeding 6 months. 5. The board may be superseded or kept under suspension in case I. of its persistent default, 2. of negligence in the performance of its duties, 3. of committing any act prejudicial to the interests of the cooperative society or its members, 4. of there being a stalemate in the constitution or functions of the board, of the election body, having failed to conduct elections in accordance with the provisions of the State Act. However, the board of any such cooperative society shall not be superseded or kept under suspension where there is no government shareholding or loan or financial assistance or any guarantee by the government. In case of supersession of a board, the administrator appointed to manage the affairs of such a cooperative society shall arrange for conduct of elections within the period of 6 months and hand over the management to the elected board. Audit of accounts of cooperative societies. The state legislature may make provisions for the maintenance of accounts by the cooperative societies and the auditing of such accounts at least once in each financial year. It shall lay down the minimum qualifications and experience of auditors and auditing firms that shall be eligible for auditing the accounts of the cooperative societies. Every cooperative society shall be audited by an auditor or auditing firm, appointed by the general body of the cooperative society. But such an auditor or auditing firm shall be appointed from a panel approved by the state government or a body authorized by the state government on this behalf. The accounts of every cooperative society shall be audited within 6 months of the close of the financial year. The audit report of the accounts of an apex cooperative society shall be laid before the state legislature. Convening of general body meetings. The state legislature may provide that the annual general body meeting of every cooperative society shall be convened within a period of 6 months of the close of the financial year. Right of a member to get information. The state legislature may provide for access to every member of a cooperative society to the books, information and accounts of the cooperative society. It may also make provisions to ensure the participation of members in the management of the cooperative society. Further, it may provide for cooperative education and training for its members. Returns. Every cooperative society shall file returns, within 6 months of the close of every financial year, to the authority designated by the state government. These returns shall include the following matters. A. Annual report of its activities. B. Its audited statement of accounts. C. Plan for surplus disposal as approved by the general body of the cooperative society. D. List of amendments to the bylaws of the cooperative society. E. Declaration regarding date of holding of its general body meeting and conduct of elections when due. F. Any other information required by the registrar in pursuance of any of the provisions of the State Act. 6. Offences and penalties. The state legislature may make provisions for the offences relating to the cooperative societies and penalties for such offences. Such a law shall include the commission or omission of the following acts as offences. A. A cooperative society willfully makes a false return or furnishes false information. B. Any person willfully disobeys any summon, requisition or order issued under the State Act. C. Any employer who, without sufficient cause, fails to pay to a cooperative society the amount deducted from its employee within a period of 14 days. D. Any officer who willfully fails to hand over custody of books, accounts, documents, records, cash, security and other property belonging to a cooperative society to an authorized person. E. Any person who adopts corrupt practices before, during or after the election of members of the board or office bearers. Application to multi-state cooperative societies. The provisions of this part shall apply to the multi-state cooperative societies subject to the modification that any reference to the state legislature, state act, or state government shall be construed as a reference to Parliament, Central Act, or central government, respectively. Application to Union territories. The provisions of this part shall apply to the Union territories. But the President may direct that the provisions of this part shall not apply to any Union territory or part thereof as he may specify in the notification. Continuance of existing laws. Any provision of any law relating to
Cooperative societies
in
in
force in the state immediately before the commencement of the Constitution, 97th Amendment, Act, 2011, which is inconsistent with the provisions of this part, shall continue to be in force until amended or repealed or until the expiration of 1 year from such commencement, whichever is less. 7 Reasons for the 97th Amendment. The reasons for adding the above provisions in the Constitution by the 97th Constitutional Amendment Act of 2011 are as follows. 1. The cooperative sector, over the years, has made significant contribution to various sectors of national economy and has achieved voluminous growth. However, it has shown weaknesses in safeguarding the interests of the members and fulfillment of objects for which these institutions were organized. There have been instances where elections have been postponed indefinitely and nominated office bearers or administrators have remained in charge of these institutions for a long time. This reduces the accountability in the management of cooperative societies to their members. Inadequate professionalism in management in many of the cooperative institutions has led to poor services and low productivity. Cooperatives need to run on well-established democratic principles and elections held on time and in a free and fair manner. Therefore, there was a need to initiate fundamental reforms to revitalize these institutions in order to ensure their contribution in the economic development of the country and to serve the interests of members and public at large, and also to ensure their autonomy, democratic functioning and professional management. 2. The cooperative societies is a subject enumerated in entry 32 of the state list of the 7th schedule of the Constitution, and the state legislatures have accordingly enacted legislations on cooperative societies. Within the framework of state acts, growth of cooperatives on large scale was envisaged as part of the efforts for securing social and economic justice and equitable distribution of the fruits of development. It has, however, been experienced that in spite of considerable expansion of cooperatives, their performance in qualitative terms has not been up to
the desired level.
Considering the need for reforms in the Cooperative Societies Acts of the states, consultations with the state governments have been held at several occasions and in the conferences of state cooperative ministers. A strong need has been felt for amending the constitution so as to keep the cooperatives free from unnecessary outside interferences and also to ensure their autonomous organizational setup and their democratic functioning. 3. The central government was committed to ensure that the cooperative societies in the country function in a democratic, professional, autonomous and economically sound manner. With a view to bring the necessary reforms, it was proposed to incorporate a new part in the Constitution so as to provide for certain provisions covering the vital aspects of working of cooperative societies like democratic, autonomous and professional functioning. It was expected that these provisions will not only ensure the autonomous and democratic functioning of cooperatives, but also ensure the accountability of management to the members and other stakeholders and shall provide for deterrence for violation of the provisions of the law. Table 60.1 Articles related to cooperative societies at a glance. Article No. Subject Matter 243ZH Definitions 243ZI Incorporation of Cooperative Societies 243ZJ Number and Term of Members of Board and its Office Bearers 243ZK Election of Members of Board 243ZL Supersession and Suspension of Board and Interim Management 243ZM Audit of Accounts of Cooperative Societies 243ZN Convening of General Body Meetings 243Z or Right of a Member to get information. 243ZP Returns 243ZQ Offences and Penalties 243ZR Application to Multi-State Cooperative Societies 243ZS Application to Union Territories 243ZT Continuance of Existing Laws Notes and References 1. In Part 3 of the Constitution, in Article 19, in Clause 1, in Subclause C, the words Cooperative Societies were inserted. 2. In Part 4 of the Constitution, a new Article 43-B was inserted, which says, the state shall endeavor to promote voluntary formation, autonomous functioning, democratic control and professional management of cooperative societies. 3. The board means the board of directors or the governing body of a cooperative society, by whatever name called, to which the direction and control of the management of the affairs of a society is entrusted to. 4. An office bearer means a president, vice president, chairperson, vice chairperson, secretary or treasurer of a cooperative society and includes any other person to be elected by the board of any cooperative society. 5. In case of cooperative banks, other than multi-state cooperative banks, this period cannot exceed 1 year. 6. The registrar means the central registrar appointed by the central government in relation to the multi-state cooperative societies and the registrar for cooperative societies appointed by the state government under the law made by the legislature of a state in relation to cooperative societies. 7. 15th February 2012 is the date of commencement of the Constitution, 97th Amendment, Act, 2011. The Centre has asked state governments to amend their respective State Cooperative Society Act in tune with the Constitution, 97th Amendment, Act, 2011 before 14th February 2013.
Official Language
Art 17 of the Constitution deals
with the official
language in
Articles
Articles 343 to 351. Its provisions are divided into four heads: language of the Union, regional languages, language of the judiciary, and texts of laws and special directives. Language of the Union. The Constitution contains the following provisions in respect of the official language of the Union. 1. Hindi written in Devanagari script is to be the official language of the Union. But the form of numerals to be used for the official purposes of the Union has to be the international form of Indian numerals and not the Devanagari form of numerals. 2. However, for a period of 15 years from the commencement of the Constitution, i.e., from 1950 to 1965, the English language would continue to be used for all the official purposes of the Union for which it was being used before 1950. 3. Even after 15 years, the Parliament may provide for the continued use of English language for the specified purposes. 4. At the end of 5 years, and again at the end of 10 years, from the commencement of the Constitution, the President should appoint a commission to make recommendations with regard to the progressive use
of the Hindi language.
Restrictions on the use of the English language and other related issues. 1. 5. A committee of Parliament is to be constituted to examine the recommendations of the Commission and to report its views on them to the President. 2. Accordingly, in 1955, the President appointed an official language commission under the chairmanship of B.G. Kare. The commission submitted its report to the President in 1956. The report was examined by a committee of Parliament constituted in 1957 under the chairmanship of Gobind Ballabh Pant. However, another official language commission, as envisaged by the Constitution, was not appointed in 1960. Subsequently, the Parliament enacted the Official Language Act in 1963. The Act provides for the continued use of English, even after 1965, in addition to Hindi, for all official purposes of the Union and also for the transaction of business in Parliament. Notably, this Act enables the use of English indefinitely, without any time limit. Further, this Act was amended in 1967 to make the use of English, in addition to Hindi, compulsory in certain cases. 3. Regional languages. The Constitution does not specify the official language of different states. In this regard, it makes the following provisions. 1. The legislature of a state may adopt any one or more of the languages in use in the state or Hindi as the official language of that state. Until that is done, English is to continue as official language of that state. Under this provision, most of the states have adopted the major regional language as their official language. For example, Andhra Pradesh has adopted Telugu, Kerala, Malayalam, Assam, Assamese, West Bengal, Bengali, Odisha, Orissa. The 9 northern states of Himachal Pradesh, Uttar Pradesh, Uttarakhand, Madhya Pradesh, Chhattisgarh, Bihar, Jharkhand, Haryana and Rajasthan have adopted Hindi. Gujarat has adopted Hindi in addition to Gujarati. Similarly, Goa has adopted Marathi in addition to Konkani. Jammu and Kashmir has adopted Urdu, and not Kashmiri. On the other hand, certain North
Eastern states like Meghalaya,
Arunachal Pradesh and Nagaland have adopted English.
Notably,
the choice of the states is not limited to the languages enumerated in the 8th schedule of the Constitution. 2. For the time being, the official language of the Union, i.e., English, would remain the link language for communications between the Union and the states or between various states. But 2 or more states are free to agree to use Hindi, instead of English, for communication between themselves. Rajasthan, Uttar Pradesh, Madhya Pradesh and Bihar are some of the states that have entered into such agreements. The Official Language Act, 1963, lays down that English should be used for purposes of communication between the Union and the non-Hindi states, that is, the states that have not adopted Hindi as their official language. Further, where Hindi is used for communication between a Hindi and a non-Hindi state, such communication in Hindi should be accompanied by an English translation. 3. When the President, on a demand being made, is satisfied that a substantial proportion of the population of a state desire the use of any language spoken by them to be recognized by that state, then he may direct that such language shall also be officially recognized in that state. This provision aims at protecting the linguistic interests of minorities in the states. Language of the judiciary and texts of laws. The constitutional provisions dealing with the language of the courts and legislation are as follows. 1. Until Parliament provides otherwise, the following are to be in the English language only. A. All proceedings in the Supreme Court and in every High Court. B. The authoritative texts of all bills, acts, ordinances, orders, rules, regulations and bylaws at the central and state levels. 4. 2. However, the governor of a state, with the previous consent of the President, can authorize the use of Hindi or any other official language of the state, in the proceedings in the High Court of the state, but not with respect to the judgments, decrees and orders passed by it. In other words,
the judgments, decrees
and orders of the High Court must continue to be in English only, until Parliament otherwise provides. 3. Similarly, a state legislature can prescribe the use of any language, other than English, with respect to bills, acts, ordinances, orders, rules, regulations or bylaws, but a translation of the same in the English language is to be published. The Official Language Act of 1963 lays down that Hindi translation of acts, ordinances, orders, regulations and bylaws published under the authority of the President are deemed to be authoritative texts. Further, every bill introduced in the Parliament is to be accompanied by a Hindi translation. Similarly, there is to be a Hindi translation of state acts or ordinances in certain cases. The Act also enables the governor of a state, with the previous consent of the President, to authorize the use of Hindi or any other official language of the state for judgments, decrees and orders passed by the High Court of the state, but they should be accompanied by an English translation. For example, Hindi is used in Uttar Pradesh, Madhya Pradesh, Bihar and Rajasthan for this purpose. However, the Parliament has not made any provision for the use of Hindi in the Supreme Court. Hence, the Supreme Court hears only those who petition or appeal in English. In 1971, a petitioner insisted on arguing in Hindi a habeas corpus petition in the Supreme Court. But the court cancelled his petition on the ground that the language of the court was English and allowing Hindi would be unconstitutional. Special directives. The Constitution contains certain special directives to protect the interests of linguistic minorities and to promote the development of Hindi language. There are protection of linguistic minorities. In this regard, the Constitution makes the following provisions. 1. Every aggrieved person has the right to submit a representation for the
redress of any
grievance to any officer or authority of the Union or a state in any of the languages used in the Union or in the state, as the case may be. This means that a representation cannot be rejected on the ground that it is not in the official language. 2. Every state and a local authority in the state should provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups. The President can issue necessary directions for this purpose. 5. 3. The President should appoint a special officer for linguistic minorities to investigate all matters relating to the constitutional safeguards for linguistic minorities and to report to him. The President should place all such reports before the Parliament and send to the state government concerned. 6. Development of Hindi language. The Constitution imposes a duty upon the centre to promote the spread and development of the Hindi language so that it may become the lingua franca of the composite culture of India. 7. Further, the centre is directed to secure the enrichment of Hindi by assimilating the forms, style and expressions used in Hindustani and in other languages specified in the 8th schedule and by drawing its vocabulary, primarily on Sanskrit and secondarily on other languages. At present, 2016, the 8th schedule of the Constitution specifies 22 languages, originally 14 languages. These are Assamese, Bengali, Bodo, Dogri, Dongri, Gujarati, Hindi, Kannada, Kashmiri, Konkani, Mathili, Methili, Malayalam, Manipuri, Marathi, Nepali, Orhia 8, Punjabi, Sanskrit, Santali, Sindhi, Tamil, Telugu and Urdu. Sindhi was added by the 21st Amendment Act of 1967, Konkani, Manipuri and Nepali were added by the 71st Amendment Act of 1992, and Bodo, Dongri, Methili and Santali were added by the 92nd Amendment Act of 2003. In terms of the Constitution provisions, there are two objectives behind the specification of the above regional languages in the 8th schedule. The members of these languages are to be given representation in the
Official Language
Commission, and b.
The
The
forms,
forms, style and expression of these languages are to be used for the enrichment of the Hindi language. Committee of Parliament on Official Language 9. The Official Language Act, 1963, provided for the setting up of a Committee of Parliament on Official Language to review the progress made in the use of Hindi for the official purpose of the Union. Under the Act, this committee was to be constituted after 10 years of the promulgation of the Act, i.e., 26 January 1965. Accordingly, this committee was set up in 1976. This committee comprises of 30 members of Parliament, 20 from Lok Sabha and 10 from Rajya Sabha. The Act contains the following provisions relating to the composition and functions of the committee. 1. After the expiration of 10 years from the date on which the Act comes into force, there shall be constituted a Committee on Official Language, on a resolution to that effect being moved in either House of Parliament with the previous sanction of the President and passed by both Houses. 2. The committee shall consist of 30 members, of whom 20 shall be members of the House of the People and 10 shall be members of the Council of States, to be elected respectively by the members of the House of the People and the members of the Council of States in accordance with the system of proportional representation by means of the single transferable vote. 3. It shall be the duty of the committee to review the progress made in the use of Hindi for the official purposes of the Union and submit a report to the President making recommendations thereon, and the President shall cause the report to be laid before each House of Parliament and send it to all the state governments. 4. The President may, after consideration of the report, and the views expressed by the state governments thereon, issue directions in accordance with the whole or any part of the report. The chairman of the committee is elected by the members of the committee. As a convention, the Union Home Minister has been elected as
Chairman of the committee from time to time.
The committee is required to submit its report along with its recommendations to the President after reviewing the position regarding the use of Hindi in central government offices on the basis of its observations. Apart from adopting other methods for assessing the factual position, the committee decided to inspect certain central government offices representing various fields of activities to motivate the central government offices to adopt maximum usage of Hindi so that the objectives of the Constitution and Official Language Act provisions could be achieved. With this end in view, the committee set up 3 subcommittees, and for the purpose of inspection by the 3 subcommittees, the various ministries, departments, etc. were divided into 3 different groups. Further, in order to assess the use of official language for various purposes and other matters connected therewith, it was also decided to invite eminent persons from various fields such as from education, judiciary, voluntary organizations and the secretaries of the ministries, departments, etc., for oral evidence. The progressive use of Hindi in the central government offices is being reviewed by the committee in the background of the provisions relating to official language as provided by the Constitution, the Official Language Act, 1963 and the rules framed thereunder. The committee also takes note of the circulars, instructions, etc. issued by the government in this regard from time to time. The terms of reference of the committee being comprehensive, it has also been examining other relevant aspects like the medium of instructions in schools, colleges and the universities, mode of recruitment to central government services and medium of departmental examination, etc. Taking into consideration the magnitude of various aspects of the official language policy and keeping in view the present circumstances, the committee in its meeting held in June 1985 and August 1986 decided to present its report to the President in parts, each part relating to a particular aspect of the official language policy. The Secretariat of the committee is headed by the Secretary of the committee. The Secretary is assisted by the officers of the level of Under Secretary and other officials. They extend all required assistance in performing the various activities of the committee. For administrative purposes, this office is subordinate office of Department of Official Language, Ministry of Home Affairs. Classical language status. In 2004, the Government of India decided to create new category of languages called as classical languages. In 2006, it laid down the criteria for conferring the classical language status. So far, 2016, the 6 languages are granted the classical language status. This is shown below in Table 61.1. Table 61.1 languages conferred with classical language status SL No. Languages. Year of declaration 1. Tamil 2004 2. Sanskrit 2005 3. Telugu 2008 4. Kannada 2008 5. Malayalam 2013 6. Or here 2014. Table 61.2 articles related to official language at a glance. Article No. Subject matter language of the Union 343. Official language of the Union 344. Commission and Committee of Parliament on Official Language. Regional languages 345. Official language or languages of a state. 346 official language for communication between one state and another or between a state and the Union. 347. Special provision relating to language spoken by a section of the population of a state. Language of the Supreme Court, High Courts, etc. 348 language to be used in the Supreme Court and in the High Courts and for acts, bills, etc. 349. Special procedure for enactment of certain laws relating to language. Special directives. 350. Language to be used in representation for redress of grievances. 350A. Facilities for instruction in mother tongue at primary stage. 350B. Special officer for linguistic minorities. 351. Directive for development of the Hindi language. Benefits. Once a language is declared classical, it gets financial assistance for setting up a center of excellence for the study of that language and also opens up an avenue for 2 major awards for scholars of eminence. Besides, the University Grants Commission can be requested to create, to begin with, at least in central universities, a certain number of professional chairs for classical languages for scholars of eminence in the language. 10 Criteria. The criteria for declaring a language as classical mandates high antiquity of its early texts, recorded history over a period of 1500 to 000 years, a body of ancient literature texts which is considered a valuable heritage by generations of speakers, and a literary tradition that is original and not borrowed from another speech community. Also, since the classical language and literature is distinct from the modern, there can also be a discontinuity between the classical language and its later forms or its offshoots. 11 Notes and references. 1. The commission was to consist of a chairman and other members representing the different languages specified in the 8th schedule of the Constitution. 2. The committee was to consist of 30 members, 20 from Lok Sabha and 10 from Rajya Sabha, to be elected in accordance with the system of proportional representation by means of the single transferable vote. 3. These include a. Resolutions, general orders, rules, notifications, administrative or other reports or press communications issued by the central government, b. Administrative and other reports and official papers laid before Parliament, and c. Contracts and agreements executed, licenses, permits, notices, etc., issued by the central government or by a corporation or a company owned by the central government. 4. For language in Parliament and a state legislature, see the respective chapters, i.e., 22 and 33. 5. This provision was added by the 7th Amendment Act of 1956 on the recommendation of the States Reorganization Commission. 6. Ibid. 7. In 1976, the Supreme Court declared Tamil Nadu's pension scheme to anti-Hindi agitators as unconstitutional. 8. The 96th Amendment Act of 2011 substituted Oriya for Oriya. 9. This information is downloaded from the website of the Committee of Parliament on Official Language, Ministry of Home Affairs, Government of India. 10. The Hindu, Oriya gets classical language status, 20th February 2014. 11. Ibid.
Public
Services
Services
Classification of Services t.e. Public services, civil services or government services, in India are classified into 3 categories: All India Services, Central Services and State Services. Their meaning and composition are explained below. All India Services are those services which are common to both central and state governments. The members of these services occupy top positions, or key posts, under both the centre and the states and serve them by turns. At present, there are 3 All India Services. They are
1.
1.
Indian
Indian
Administrative
Service,
IAS.
IAS. 2. Indian Police Service, IPS. 3. Indian Forest Service, IFS. In 1947, the Indian Civil Service, ICS, was replaced by IAS, and the Indian Police, IP, was replaced by IPS and were recognized by the Constitution as All India Services. In 1966, the Indian Forest Service was established as the 3rd All India Service 1. The All India Services Act of 1951 authorized the central government to make rules in consultation with the state governments for the regulation of recruitment and service conditions of the members of All India Services. The
Members of these services
are recruited and trained by the central government but are assigned to different states for work. They belong to different state cadre, the centre having no cadre of its own in this regard. They serve the central government on deputation, and after completing their fixed tenure they go back to their respective states. The central government obtains the services of these officers on deputation under the well-known tenure system. It must be noted here that irrespective of their division among different states, each of these All India Services form a single service with common rights and status and uniform scales of pay throughout the country. Their salaries and pensions are met by the states. The All India Services are controlled jointly by the central and state governments. The ultimate control lies with the central government while the immediate control is vested in the state governments. Any disciplinary action, imposition of penalties, against these officers can only be taken by the central government. Sardar Vallabhbhai Patel was the chief protagonist of All India Services in the Constituent Assembly. Hence, he came to be regarded as the father of All India Services. Central Services. The personnel of Central Services work under the exclusive jurisdiction of the central government. They hold specialized, functional and technical positions in various departments of the central government. Before independence, the Central Services were classified into Class I, Class II, subordinate and inferior services. After independence, the nomenclature of subordinate and inferior services was replaced by Class III and Class IV services. Again in 1974, the classification of Central Services into Class I, Class II, Class III and Class IV was changed to Group A, Group B, Group C and Group D, respectively too. At present, there are 60 Group A Central Services. Some of them are 1 Central Engineering Service, 2 Central Health Service, 3 Central Information Service, 4 Central Legal Service, 5 Central Secretariat Service, 6 Indian Audit and Accounts Service, 7 Indian Defence Accounts Service, 8 Indian Economic Service, 9 Indian Foreign Service, 10 Indian Meteorological Service, 11 Indian Postal Service, 12 Indian Revenue Service, Customs, Excise and Income Tax, 13 Indian Statistical Service, 14 Overseas Communication Service, 15 Railway Personnel Service. Most of the above category of Group A central services have also corresponding Group B services. The Group C central services consists of clerical personnel while Group D consists of manual personnel. Thus Group A and Group B comprises of gazetted officers while Group C and Group D are non-gazetted. Among all, the Indian Foreign Service, IFS, is the highest central service in terms of prestige, status, pay and emoluments. In fact, it, though a central service, competes with the All India services in position, status and pay scales. It comes next to the IAS in ranking and its pay scale is higher than the IPS. State services. The personnel of state services work under the exclusive jurisdiction of the state government. They hold different positions, general, functional and technical, in the departments of the state government. However, they occupy lower positions, in the administrative hierarchy of the state, than those held by the members of the All India services, IAS, IPS and IFS. The number of services in a state differ from state to state. The services that are common to all the states are 1. Civil service, 2. Police service, 3. Forest service, 4. Agricultural service, 5. Medical service, 6. Veterinary service, 7. Fisheries service, 8. Judicial service, 9. Public health service, 10. Educational service, 11. Cooperative service, 12. Registration service, 13. Sales tax service, 14. Jail service, 15. Service of engineers. Each of these services is named after the state, that is, name of the state is added as a prefix. For example, in Andhra Pradesh, AP, they are known as AP Civil Service, AP Police Service, AP Forest Service, AP Agricultural Service, AP Medical Service, AP Veterinary Service, AP Fisheries Service, AP Judicial Service, and so on. Among all the state services, the civil service, also known as the administrative service, is the most prestigious. Like the central services, the state services are also classified into 4 categories: Class I, Group I or Group A, Class II, Group II or Group B, Class III, Group III or Group C, and Class IV, Group IV or Group D. Further, the state services are also classified into gazetted class and non-gazetted class. Usually, Class I, Group A, and Class II, Group B, services are gazetted classes while Class III, Group C, and Class IV, Group D, services are non-gazetted classes. The names of the members of gazetted class are published in the Government Gazette for appointment, transfer, promotion and retirement, while those of the non-gazetted are not published. Further, the members of the gazetted class enjoy some privileges which are denied to the members of non-gazetted class. Also, the members of the gazetted class are called officers, while those of non-gazetted are called employees. The All India Services Act of 1951 specifies that senior posts not exceeding 33 1/3% in the Indian Administrative Service, IAS, Indian Police Service, IPS, and Indian Forest Service, IFS, are required to be filled in by promotion of officers employed in the state services. Such promotions are made on the recommendation of selection. Committee constituted for this purpose in each state. Such a committee is presided over by the chairman or a member of UPSC. Constitutional provisions Articles 308 to 314 in Part 14 of the Constitution contain provisions with regard to all India services, central services and state services. Article 308 makes it clear that these provisions do not apply to the state of Jammu and Kashmir. 1. Recruitment and service conditions. Article 309 empowers the Parliament and the state legislatures to regulate the recruitment and the conditions of service of the persons appointed to public services and posts under the centre and the states, respectively. Until such laws are made, The President or the Governor can make rules to regulate these matters. Recruitment includes any method provided for inducting a person in public service like appointment, selection, deputation, promotion and appointment by transfer. The conditions of service of a public servant includes pay, allowances, periodical increments, leave, promotion, tenure or termination of service, transfer, deputation, various types of rights, disciplinary action, holidays, hours of work and retirement benefits like pension, provident fund, gratuity and so on. Under this provision, the Parliament or the state legislature can impose reasonable restrictions on the fundamental rights of public servants in the interests of integrity, honesty, efficiency, discipline, impartiality, secrecy, neutrality, anonymity, devotion to duty and so on. Such restrictions are mentioned in the conduct rules like central services, conduct rules, railway services, conduct rules and so on. To tenure of office according to Article 310, members of the defense services, the civil services,
of the Centre
and the All India services or persons holding military posts or civil posts free under the Centre, hold office during the pleasure of the President. Similarly, members of the civil services of a state or persons holding civil posts under a state, hold office during the pleasure of the Governor of the state. However, there is an exception to this general rule of dismissal at pleasure. The President or the Governor may, in order to secure the services of a person having special qualifications, provide for the payment of compensation to him in two cases: I, if the post is abolished before the expiration of the contractual period, or 2, if he is required to vacate that post for reasons not connected with misconduct on his part. Notably, such a contract can be made only with a new entrant, that is, a person who is not already a member of a defense service, a civil service of the Centre, an All India service or a civil service of a state. 3 Safeguards to civil servants. Article 311 places 2 restrictions on the above doctrine of pleasure. In other words, it provides 2 safeguards to civil servants against any arbitrary dismissal from their posts. A civil servant cannot be dismissed or removed by an authority subordinate to that by which he was appointed. B. A civil servant cannot be dismissed or removed or reduced in rank 5 except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. The above 2 safeguards are available only to the members of the civil services of the Centre, the All India services, the civil services of a state, or to persons holding civil posts under the Centre or a state, and not to the members of defence services or persons holding military posts. However, the second safeguard, holding inquiry, is not available in the following 3 cases: a. Where a civil servant is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on a criminal charge, or b. Where the authority empowered to dismiss or remove a civil servant or to
reduce him in rank is
satisfied that for some reason, to be recorded in writing, it is not reasonably practicable to hold such inquiry, or c. Where the President or the Governor is satisfied that in the interest of the security of the state, it is not expedient to hold such inquiry. Originally, the opportunity of being heard was given to a civil servant at 2 stages, at the inquiry stage, and at the punishment stage. But the 42nd Amendment Act of 1976 abolished the provision for second opportunity, that is, the right of a civil servant to make representation against the punishment proposed as a result of the findings of the inquiry. Hence, the present position is that where it is proposed, after inquiry, to impose upon a civil servant the punishment of dismissal, removal or reduction in rank, it may be imposed on the basis of the evidence adduced at the inquiry without giving him any opportunity of making representation on the penalty proposed. The Supreme Court held that the expression reasonable opportunity of being heard, envisaged to a civil servant, in the second safeguard mentioned above, includes a. an opportunity to deny his guilt and establish his innocence, which he can only do if he is told what the charges leveled against him are and the allegations on which such charges are based. b. An opportunity to defend himself by cross-examining the witnesses produced against him and by examining himself or any other witnesses in support of his defense, and c. The disciplinary authority must supply a copy of the inquiry officer's report to the delinquent civil servant for observations and comments before the disciplinary authority considers the report. For All India Services, Article 312 makes the following provisions in respect of All India Services. The Parliament can create new All India Services, including an All India Judicial Service, if the Rajya Sabha passes a resolution declaring that it is necessary or expedient in the national interest to do so. Such a resolution in the Rajya Sabha should be supported by 2/3 of the members present and voting. This power of recommendation is given to the Rajya Sabha to protect the interests of states in the Indian federal system. B. Parliament can regulate the recruitment and conditions of service of persons appointed to All India Services. Accordingly, the Parliament has enacted the All India Services Act, 1951 for the purpose. C. The services known at the commencement of the Constitution, that is, 26 January 1950, as the Indian Administrative Service and the Indian Police Service are deemed to be services created by Parliament under this provision. D. The All India Judicial Service should not include any post inferior to that of a district judge. 6. A law providing for the creation of this service is not to be deemed as an amendment of the Constitution for the purposes of Article 368. Though the 42nd Amendment Act of 1976 made the provision for the creation of All India Judicial Service, no such law has been made so far. 5 other provisions. Article 312A, inserted by the 28th Amendment Act of 1972, confers powers on the Parliament to vary or revoke the conditions of service of persons who were appointed to a civil service of the Crown in India before 1950. Article 313 deals with transitional provisions and says that until otherwise provided, all the laws enforced before 1950 and applicable to any public service would continue. Article 314, which made provision for protection of existing officers of certain services, was repealed by the 28th Amendment Act of 1972. Table 62.1 Articles related to public services at a glance. Article No. Subject Matter 308. Interpretation 309. Recruitment and conditions of service of persons serving the Union or a state 310. Tenure of office of persons serving the Union or a state 311. Dismissal, removal or reduction in rank of persons employed in civil capacities under the Union or a state. 312 All India Services 312A. Power of Parliament to vary or revoke conditions of service of officers of certain services 313. Transitional Provisions 314. Provision for protection of existing officers of certain services, repealed. Notes and references. 1. In 1963, a provision was made for the creation of 3 more All India Services. They were Indian Forest Service, Indian Medical and Health Service and Indian Service of Engineers. However, out of these 3, only the Indian Forest Service came into existence in 1966. This was done on the recommendation of the Third Pay Commission, 1970-1973, while the earlier change was done on the recommendation of the First Pay Commission, 1946-1947. 3. A civil post means an appointment or office or employment on the civil side of the administration as distinguished from the military side. For the difference between dismissal and removal is that the former disqualifies for future employment under the government while the latter does not disqualify for future employment under the government. 5. Reduction in rank means reduction from a higher to a lower rank or post. It is a penalty imposed on a civil servant. 6. The expression, district judge, includes judge of a city civil court, additional district judge, joint district judge, assistant district judge, chief judge of a small coast court, chief presidency magistrate, Additional Chief Presidency Magistrate, Sessions Judge, Additional Sessions Judge and Assistant Sessions Judge.
Tribunals.
The original constitution did not contain provisions with respect to
Tribunals.
The 42nd Amendment Act of 1976 added a new part 1480 to the Constitution. This part is entitled as Tribunals and consists of only 2 articles. Article 323 dealing with administrative tribunals and Article 323b dealing with tribunals for other matters. Administrative Tribunals Article 323a empowers the Parliament to provide for the establishment of administrative tribunals for the adjudication of disputes relating to recruitment and conditions of service of persons appointed to public services of the centre, the states, local bodies, public corporations and other public authorities. In other words, Article 323a enables the Parliament to take out the adjudication of disputes relating to service matters from the civil courts and the high courts and place it before the administrative tribunals. In pursuance of Article 323a, the Parliament has passed the Administrative Tribunals Act in 1985. The Act authorizes the central government to establish one central administrative tribunal and the state administrative tribunals. This Act opened a new chapter in the sphere of providing speedy and inexpensive justice to the aggrieved public servants. Central Administrative Tribunal, CAT.
The Central Administrative Tribunal,
CAT, was set up in 1985 with the principal bench at Delhi and additional benches in different states. At present, it has 17 regular benches, 15 of which operate at the principal seats of high courts and the remaining 2 at Jaipur and Lucknow 1. These benches also hold circuit sittings at other seats of high courts. The CAT exercises original jurisdiction in relation to recruitment and all service matters of public servants covered by it. Its jurisdiction extends to the All India Services, the Central Civil Services, civil posts under the centre and civilian employees of defence services. However, the members of the defence forces, officers and servants of the Supreme Court and the secretarial staff of the Parliament are not covered by it. The CAT is a multi-member body consisting of a chairman and members. Earlier, the CAT consisted of a chairman, vice-chairman and members. With the amendment in Administrative Tribunals Act, 1985 in 2006, the members have been given the status of judges of high courts. At present, 2016, the sanctioned strength of the chairman is 1 and sanctioned strength of the members is 65. They are drawn from both judicial and administrative streams and are appointed by the President. They hold office for a term of 5 years or until they attain the age of 65 years, in case of chairman and 62 years in case of members, whichever is earlier. The appointment of members in CAT is made on the basis of recommendations of a high-powered selection committee chaired by a sitting judge of Supreme Court who is nominated by the Chief Justice of India. After obtaining the concurrence of Chief Justice of India, appointments are made with the approval of Appointments Committee of the Cabinet, ACC. The CAT is not bound by the procedure laid down in the Civil Procedure Code of 1908. It is guided by the principles of natural justice. These principles keep the CAT flexible in approach. Only a nominal fee of 50 is to be paid by the applicant. The applicant may appear either in person or through a lawyer. Originally, appeals against the orders of the CAT could be made only in the Supreme Court and not in the High Courts. However, in the Chandra Kumar case 2, 1997, the Supreme Court declared this restriction on the jurisdiction of the High Courts as unconstitutional, holding that judicial review is a part of
the basic structure of the Constitution.
It laid down that appeals against the orders of the CAT shall lie before the division bench of the concerned High Court. Consequently, now it is not possible for an aggrieved public servant to approach the Supreme Court directly against an order of the CAT, without first going to the concerned High Court. State Administrative Tribunals. The Administrative Tribunals Act of 1985 empowers the central government to establish the State Administrative Tribunals, SATs, on specific request of the concerned state governments. So far, 2016, the SATs have been set up in the 9 states of Andhra Pradesh, Himachal Pradesh, Odisha, Karnataka, Madhya Pradesh, Maharashtra, Tamil Nadu, West Bengal and Kerala. However, the Madhya Pradesh, Tamil Nadu and Himachal Pradesh tribunals have since been abolished. The Kerala Administrative Tribunal was set up with effect from 26 August 2010. But subsequently Himachal Pradesh re-established the SAT and the state of Tamil Nadu has also requested now to re-establish the same. Like the CAT, the SATs exercise original jurisdiction in relation to recruitment and all service matters of state government employees. The chairman and members of the SATs are appointed by the President after consultation with the governor of the state concerned. The Act also makes a provision for setting up of Joint Administrative Tribunal, JAT, for 2 or more states. A JAT exercises all the jurisdiction and powers exercisable by the administrative tribunals for such states. The chairman and members of a JAT are appointed by the President after consultation with the governors of the concerned states. Tribunals for other matters under Article 323b, the Parliament and the state legislatures are authorized to provide for the establishment of tribunals for the adjudication of disputes relating to the following matters: a. Taxation, b. Foreign exchange, import and export,
C. Industrial and labor.
d. Land reforms, e. Sealing on urban property, f. Elections to Parliament and state legislatures, g. Foodstuffs, h. Rent and tenancy rights. 3. Articles 323a and 323b differs in the following 3 aspects. 1. While Article 323a contemplates establishment of tribunals for public service matters only, Article 323b contemplates establishment of tribunals for certain other matters, mentioned above. 2. While tribunals under Article 323a can be established only by Parliament, tribunals under Article 323b can be established both by Parliament and state legislatures with respect to matters falling within their legislative competence. 3. Under Article 323a, only 1 tribunal for the centre and 1 for each state or 2 or more states may be established. There is no question of hierarchy of tribunals, whereas under Article 323b a hierarchy of tribunals may be created. In Chandra Kumar Case 4, 1997, the Supreme Court declared those provisions of these 2 articles which excluded the jurisdiction of the High Courts and the Supreme Court as unconstitutional. Hence, the judicial remedies are now available against the orders of these tribunals. Table 63.1 Name and jurisdiction of benches of CAT SL. No. Bench territorial jurisdiction of the Bench 1. Principal Bench, Delhi 2. Allahabad Bench Uttar Pradesh, except the districts covered by Lucknow Bench, 3. Lucknow Bench Uttar Pradesh, except the districts covered by the Allahabad Bench, Cuttack.
4. Bench Orissa 5.
Hyderabad Bench Andhra Pradesh 6. Bangalore Bench Karnataka 7. Madras Bench Tamil Nadu and Puducherry 8. Ernakulam Bench Kerala and Lakshadweep 9. Bombay Bench Maharashtra, Goa, Dadra and Nagar Haveli, Andaman and DU 10. Ahmedabad Bench Gujarat 11. Jodhpur Bench Rajasthan, except the districts covered by the Jaipur Bench, 12. Jaipur Bench Rajasthan, except the districts covered by the Jodhpur Bench, 13. Chandigarh Bench J&K, Haryana, Himachal Pradesh, Punjab and Chandigarh 14. Jabalpur Bench Madhya Pradesh 15. Patna Bench Bihar 16. Calcutta Bench West Bengal, Sikkim and Andaman and Nicobar Islands 17. Guwahati Bench Assam, Meghalaya, Manipur, Tripura, Nagaland, Mizoram and Arunachal Pradesh. Table 63.2 Circuit sittings of benches of CAT
SL. No bench circuit sittings held at 1.
Allahabad Bench Nainital 2. Calcutta Bench Port Blair, Gangtok 3. Chandigarh Bench Shimla, Jammu 4. Madras Bench Puducherry 5. Guwahati Bench Shillong, Itanagar, Kohima, Agartala, Imphal 6. Jabalpur Bench Indore, Gwalior, Bilaspur 7. Bombay Bench Nagpur, Aurangabad, Panaji 8. Patna Bench Ranchi 9. Ernakulam Lakshadweep Bench Table 63.3 Articles
Related to tribunals at a glance. Article No.
Subject Matter 323A. Administrative Tribunals 323B. Tribunals for other matters. Notes and references 1. See Table 63.1 at the end of this chapter. 2. L. Chandra Kumar v. Union of India, 1997. Clause 2, d, of Article 323 was declared as unconstitutional. 3. Added by the 75th Amendment Act of 1993. 4. L. Chandra Kumar v. Union of India, 1997. Clause 2, d, of Article 323A and Clause 3, d, of Article 323B were declared as unconstitutional.
Rights and liabilities of the government.
Articles 294 to 300 in Part 12 of the Constitution deal with the property, contracts, rights, liabilities, obligations and suits of the Union and the states. In this regard, the Constitution makes the Union or the states as juristic legal persons. Property of the Union and the states. 1. Succession. All property and assets that were vested in the Dominion of India or a province or an Indian princely state, before the commencement of the present Constitution, became vested in the Union or the corresponding state. Similarly, all rights, liabilities and obligations of the government of the Dominion of India or a province or an Indian state would now be the rights, liabilities and obligations of the government of India or the corresponding state. 2. Escheat, lapse and bona vacantia. Any property in India that would have accrued to King of England or ruler of Indian state, princely, by escheat, death of a person in state without any heir, lapse, termination of rights through disuse or failure to follow.
Appropriate procedures,
or bona vacantia, property found without any owner, for want of a rightful owner, would now vest in the state if the property is situated there, and in the Union, in any other case. In all these three cases, the property accrues to the government as there is no rightful owner, claimant. 3. Sea wealth. All lands, minerals and other things of value under the waters of the ocean within the territorial waters of India, the continental shelf of India and the exclusive economic zone of India vests in the Union. Hence, a state near the ocean cannot claim jurisdiction over these things. India's territorial waters extend to a distance of 12 nautical miles from the appropriate baseline. Similarly, India's exclusive economic zone extends up to 200 nautical miles. 1. 4. Compulsory acquisition. By law, the Parliament as well as the state legislatures are empowered to make laws for the compulsory acquisition and requisitioning of private property by the governments. Further, the 44th Amendment Act, 1978, has also abolished the constitutional obligation to pay compensation in this regard except in two cases: a. when the government acquires the property of a minority educational institution, and b. when the government acquires the land held by a person under his personal cultivation and the land is within the statutory ceiling limits. 2. 5. Acquisition. Under executive power, the Union or a state can acquire, hold and dispose property under the exercise of its executive power. Further, the executive power of the Union or a state extends to the carrying on any trade or business within and in other states also. Suits by or against the government. Article 300 of the Constitution deals with the suits by or against the
government in India. It lays down that the government of
India may sue or be sued by the name of the Union of India, and government of a state may sue or be sued by the name of that state, e.g., State of Andhra Pradesh or State of Uttar Pradesh, and so on. Thus, the Union of India and states are legal entities, juristic personalities, for purposes of suits and proceedings, not the government of the Union or government of states. Regarding the extent of the governmental liability, the Constitution, Article 300, declares that the Union of India or states can sue or be sued in relation to their respective affairs in the like cases as the Dominion of India and the corresponding provinces or Indian states might have sued or been sued before the Constitution. This provision is subject to any law made by Parliament or a state legislature. But no such law has been enacted so far. Hence, at present, the position in this respect remains the same as it existed before the Constitution. In the pre-Constitution period, i.e., from the days of the East India Company up to the commencement of the Constitution in 1950, the government was suable for contracts but not for torts, wrongs committed by its servants, in respect of its sovereign functions. This is explained in detail as follows: 1. Liability for contracts under the exercise of its executive power. The union or a state can enter into contracts for the acquisition, holding and disposal of property, or to carry on any trade or business, or for any other purpose. But the Constitution lays down 3 conditions which must be fulfilled by such contracts. A. They must be expressed to be made by the President or Governor, as the case may be. B. They must be executed on behalf of the President or Governor, as the case may be. And C. They must be executed by such person or in such manner as the President or Governor may direct or authorize. These conditions are mandatory and not merely directory in nature. Failure to comply with them nullifies the contracts and renders them void and unenforceable in the courts. Further, the President or the Governor is not personally liable in respect of
any contract executed
in his name. Similarly, the officer executing the contract is also not personally liable. This immunity is purely personal and does not immunize the government from a contractual liability, making the government suable in contracts. This means that the contractual liability of the union government and the state governments is the same as that of an individual under the ordinary law of contract, which has been the position in India since the days of the East India Company. 2. Liability for torts. In the beginning, the East India Company was only a trading body. Gradually, it acquired territories in India and became a sovereign authority. The company was suable for its functions as a trader but not as a sovereign. This immunity of the company in respect of its sovereign functions was based on the English common law maxim that the king can do no wrong, which means that the king was not liable for wrongs of his servants. This traditional immunity of the state, i.e., Crown, in Britain from any legal liability for any action has been done away by the Crown Proceedings Act, 1947. However, the position in India still remains the same. Therefore, the government, union or states, in India can be sued for torts, civil wrongs, committed by its officials only in the exercise of its non-sovereign functions but not in the sovereign functions like administering justice, constructing a military road, commanding goods during war, etc. This distinction between the sovereign and non-sovereign functions of the government in India and the immunity of the government in respect of its sovereign functions was established in the famous P&O Steam Navigation Company Case 3, 1861. This was reaffirmed by the Supreme Court in the post-independence era in the Kasturilal Case 4, 1965. However, after this case, the Supreme Court started giving a restrictive interpretation to sovereign functions of the government and awarded compensation to victims in a large number of cases. In Nagendra Rao Case 4A, 1994, the Supreme Court criticized the doctrine of sovereign immunity of the state and adopted a liberal approach with respect to the tortuous liability of the state. It ruled that when a citizen suffers any damage due to the negligent act of the servants of the state
would be liable to pay
compensation for it, and the state cannot avoid this liability on the ground of sovereign immunity. It held that in the modern sense, the distinction between
sovereign and non-sovereign functions does not exist.
It laid down the proposition that barring a few functions, the state cannot claim any immunity. Its observations, in this case, are as follows. 1. No civilized system can permit an executive to play with the people of its country and claim that it is entitled to act in any manner as it is sovereign. The concept of public interest has changed with structural change in the society. No legal or political system today can place the state above law, as it is unjust and unfair for a citizen to be deprived of his property illegally by negligent act of officers of the state without any remedy. The modern social thinking of progressive societies and the judicial approach is to do away with archaic state protection and place the state or the government at par with any other juristic legal entity. Any watertight compartmentalization of the functions of the state as sovereign and non-sovereign, or governmental and non-governmental, is not sound. It is contrary to modern jurisprudential thinking. 3. The need of the state, duty of its officials and right of the citizens are required to be reconciled so that the rule of law in a welfare state is not shaken. In a welfare state, the functions of the state are not only the defense of the country or administration of justice or maintaining law and order, but it extends to regulating and controlling the activities of the people in almost every sphere: educational, commercial, social, economic, political and even marital. 4. The demarcating line between sovereign and non-sovereign powers, for which no rational basis survives, has largely disappeared. Therefore, barring functions such as administration of justice, maintenance of law and order and repression of crime, etc., which are among the primary and inalienable functions of a constitutional government, the state cannot claim any immunity. In the above case, the Supreme Court did not overrule its judgment in the Kasturilal case, 1965. However, it said that it is applicable to rare and limited cases. In Common Cause Case 4B, 1999, the Supreme Court again examined the whole doctrine and rejected the sovereign immunity rule. The court held that the rule of state liability as laid down in P&O Steam Navigation Company case is very outmoded. It said that in modern times, when the state activities have been considerably increased, it is very difficult to draw a line between its sovereign and non-sovereign functions. The increased activities of the state have made a deep impression on all facets of citizens' life, and therefore, the liability of the state must be made coextensive with the modern concept of a welfare state. The state must be liable for all tortuous acts of its employees, whether done in exercise of sovereign or non-sovereign powers. 4c. Finally, the court observed that the efficacy of Kasturilal case as a binding precedent has been eroded. In the prisoner's murder case 4d, 2000, the Supreme Court ruled that in the process of judicial advancement, Kasturilal case has paled into insignificance and is no longer of any binding value. Suits against public officials. 1. President and Governor. The Constitution confers certain immunities to the President of India and Governor of States with regard to their official acts and personal acts. These are: a. Official acts. The President and the Governors cannot be sued during the term of their office or thereafter, for any act done by them in the exercise and performance of their official powers and duties. However, the official conduct of the President can be reviewed by a court, tribunal or any other body authorized by either House of Parliament to investigate charges for impeachment. Further, the aggrieved person can bring appropriate proceedings against the Union of India instead of the President and the state instead of the Governor of that state. b. Personal acts. No criminal proceedings can be started against the President and the Governors in respect of their personal acts, nor can they be arrested or imprisoned. This immunity is limited to the period of the term of their office only and does not extend beyond that. However, civil proceedings can be started against them during their term of office in respect of their personal acts after giving 2 months advance notice. To ministers, the Constitution does not grant any immunity to the ministers for their official acts. But, since they are not required to countersign, as in Britain, the official acts of the President and the Governors, they are not liable in the courts for those acts. 5. Moreover, they are not liable for the official acts done by the President and the Governors on their advice, as the courts are debarred from inquiring into such advice. However, the ministers do not enjoy any immunity for their personal acts, and can be sued for crimes as well as torts in the ordinary courts like common citizens. 3. Judicial officers. The judicial officers enjoy immunity from any liability in respect of their official acts and hence cannot be sued. The Judicial Officers Protection Act, 1850, lays down that no judge, magistrate, justice of peace, collector or other person acting judicially shall be liable to be sued in any civil court for any act done by him in the discharge of his official duty. For civil servants under the Constitution, the civil servants are conferred personal immunity from legal liability for official contracts. This means that the civil servant who made a contract in his official capacity is not personally liable in respect of that contract, but it is the government, central or state, that is liable for the contract. But, if the contract is made without complying the conditions specified in the Constitution, then the civil servant who made the contract is personally liable. Further, the civil servants also enjoy immunity from legal liability for their tortious acts in respect of the sovereign functions of the government. In other cases, the liability of the civil servants for torts or illegal acts is the same as of any ordinary citizen. Civil proceedings can be instituted against them for anything done in their official capacity after giving a 2 months advance notice. But, no such notice is required when the action is to be brought against them for the acts done outside the scope of their official duties. Criminal proceedings can be instituted against them for acts done in their official capacity, with the prior permission of the President or the Governor, where necessary. 6. Table 64.1 Articles related to rights and liabilities of the government at a glance. Article No. Subject Matter 294. Succession to property, assets, rights, liabilities and obligations in certain cases. 295. Succession to property, assets, rights, liabilities and obligations in other cases. 296. Property accruing by escheat or lapse or as bona vacantia. 297. Things of value within territorial waters or continental shelf and resources of the exclusive economic zone to west in the Union. 298. Power to carry on trade, etc. 299. Contracts. 300. Suits and proceedings. 361. Protection, immunities, of President and Governor's notes and references. 1. Under the Territorial Waters, Continental Shelf, Exclusive Economic Zone and Other Maritime Zones Act, 1976, passed by the Parliament after the 40th Constitutional Amendment Act, 1976. 2. The first provision was added by the 44th Amendment Act, 1978. This amendment abolished the fundamental right to property and made it a legal right. The second provision was added by the 17th Amendment Act, 1964. 3. Peninsular and Oriental Steam Navigation Company v. Secretary of State.
For India,
1861. 4. Kasturilal v. State of UP, 1965. 4. A. N. Nagendra Rao and Co. v. State of Andhra Pradesh, 1994. 4. B. Common Cause, Registered Society v. Union of India, 1999. 4. C. J. N. Pandey, The Constitutional Law of India, 49th edition, Central Law Agency, p.682.
4. D. State of AP v.
Challa Ramakrishna Reddy, 2000. 5. In Britain, the ministers are required to countersign the official acts of the Crown and are held liable in the courts for those acts. 6. Criminal Procedure Code says, where a public servant who is not removable from his office save by or with the sanction of the central or state government is accused of an offence committed by him while acting or purporting to act in the discharge of his official duty, no court can take cognizance of such offence without the previous sanction of the central government or the state government, as the case may be.
Authoritative text of
The Constitution in Hindi language. Constitutional provisions. Originally, the Constitution of India did not make any provision with respect to an authoritative text of the Constitution in the Hindi language. Later, a provision in this regard was made by the 58th Constitutional Amendment Act of 19,871. This amendment inserted a new Article 394- in the last part of the Constitution, i.e., Part 22(2). This article contains the following provisions. 1. The President shall cause to be published under his authority, i. the translation of the Constitution in Hindi language. The modifications which are necessary to bring it in conformity with the language, style and terminology adopted in the authoritative texts of the central acts in Hindi can be made in it. All the amendments of the Constitution made before such publication should be incorporated in it. 2. The translation in Hindi of every amendment of the Constitution made in English. 2. The translation of the Constitution and its every amendment published shall be construed to have the same meaning as the original text in
English.
If any difficulty arises in this matter, the President shall cause the Hindi text to be revised suitably.
3. The translation of the Constitution and its every amendment published shall be deemed to be,
for all purposes, its authoritative text in Hindi. Reasons for the 58th Amendment. The reasons for adding the above provisions in the Constitution by the 58th Constitutional Amendment Act of 1987 are as follows. The Constitution of India adopted by the Constituent Assembly on 26 November 1949 was in the English language. A Hindi translation of the Constitution, signed by the members of the Constituent Assembly, was also published in 1950 under the authority of the President of the Constituent Assembly. 3. There had been a general demand for the publication of an authoritative text of the Constitution in Hindi incorporating in it all the subsequent amendments. It has also been imperative to have an authoritative text of the Constitution in the Hindi language for facilitating its use in the legal process. Further, any Hindi version of the Constitution should not only conform to the Hindi translation published by the Constituent Assembly in 1950, but should also be in conformity with the language, style and terminology adopted in the authoritative texts of the central acts in Hindi. It was, therefore, proposed to amend the Constitution so as to empower the President of
India to publish under his authority the translation
of the Constitution and its every amendment in Hindi language. In pursuance of Article 394-, the President published in the Gazette of India an authoritative text of the Constitution of India in the Hindi language. Notes and references. 1. The 56th Constitutional Amendment Bill of 1987, after being passed by both the Houses of Parliament and assented by the President, finally emerged as the 58th Constitutional Amendment Act of 1987. 2. Part 22 is entitled as, short title, Commencement, Authoritative Text in Hindi and Repeals. Originally, this part consisted of 3 articles only: Article 393, short title, Article 394, Commencement, and Article
395, Repeals. 3. In accordance with a resolution adopted by the Constituent Assembly. Special provisions relating to certain classes. Rationale of special provisions. In order to realize the objectives of equality and justice as laid down in the preamble, the Constitution makes special provisions for the scheduled castes, SCs, the scheduled tribes, STs, the backward classes, BCs, and the Anglo-Indians. These special provisions are contained in Part 16 of the Constitution from Articles 330 to 342. They are related to the following: 1. Reservation in legislatures. 2. Special representation in legislatures. 3. Reservation in services and posts. 4. Educational grants. 5. Appointment of national commissions. 6. Appointment of commissions of investigation. These special provisions can be classified into the following broad categories: A. Permanent and temporary. Some of them are a permanent feature of the Constitution, while some others continue to operate only for a specified period. B. Protective and developmental. Some of them aim at protecting these classes from all forms of injustice
and exploitation, while some others aim at promoting their socio-economic interests. Specification of classes. The Constitution does not specify the castes or tribes which are to be called the SCs or the STs.
It leaves to the President the power to specify as to what castes or tribes in each state and union territory are to be treated as the Scs and Sts. Thus, the lists of the Scs or Sts vary from state to state and union territory to union territory. In case of the states, the President issues the notification after consulting the governor of the state concerned. But, any inclusion or exclusion of any caste or tribe from presidential notification can be done only by the Parliament and not by a subsequent presidential notification. Presidents have issued several orders specifying the Scs and Sts in different states and union territories, and these have also been amended by the Parliament. 1 Similarly, the Constitution has neither specified the BCs nor used a single uniform expression to characterize the BCs. 2 The expression, BCs, means such backward classes of citizens other than the Scs and the Sts as may be specified by the central government. Thus the expression, BCs, in this context means the other backward classes, OBCs, as the Scs and Sts are also backward classes of citizens. Unlike in the case of Scs, Sts and OBCs, the Constitution has defined the persons who belong to the Anglo-Indian community. Accordingly, an Anglo-Indian means a person whose father or any of whose other male progenitors in the male line is or was of European descent but who is domiciled within the territory of India and is or was born within such territory of parents habitually resident therein and not established there for temporary purposes only. Components of special provisions. 1. Reservation for Scs and Sts and special representation for Anglo-Indians in legislatures. Seats are to be reserved for the Scs and Sts in the Lok Sabha and the state legislative assemblies on the basis of population ratios. The President can nominate 2 members of the Anglo-Indian community to the Lok Sabha, if the community is not adequately represented. Similarly, the governor of a state can nominate 1 member of the Anglo-Indian community to the state legislative assembly, if the community is not adequately represented. Originally, these 2 provisions of reservation and special representation were to operate for 10 years, i.e., up to 1960, only. But this duration has been extended continuously since then by 10 years each time. Now, under the 95th Amendment Act of 2009, these 2 provisions of reservation and special representation are to last until 2020.3. The reasons for the extension of the above 2 provisions of reservation and special representation by the 95th Amendment Act of 2009 are as follows. 3a. I. Article 334 of the Constitution lays down that the provisions of the Constitution relating to the reservation of seats for the scheduled castes and the scheduled tribes and the representation of the Anglo-Indian community by nomination in the House of the People and the legislative assemblies of the states shall cease to have effect on the expiration of the period of 60 years from the commencement of the Constitution. In other words, these provisions will cease to have effect on the 25th January 2010, if not extended further. 2. Although the scheduled castes and the scheduled tribes have made considerable progress in the last 60 years, the reasons which weighed with the Constituent Assembly in making provisions with regard to the aforesaid reservation of seats and nomination of members have not ceased to exist. It is, therefore, proposed to continue the reservation for the scheduled castes and the scheduled tribes and the representation of the Anglo-Indian community by nomination for a further period of 10 years. The reason for this special representation to the Anglo-Indians is as follows. Anglo-Indians constitute a religious, social, as well as a linguistic minority. These provisions were necessary, for, otherwise, being numerically an extremely small community, and being interspersed all over India, the Anglo-Indians could not hope to get any seat in any legislature through election. 4.2. Claims of Scs and Sts to services and posts. The claims of the Scs and Sts are to be taken into consideration while making appointments to the public services of the centre and the states, without sacrificing the efficiency of administration. However, the 82nd Amendment Act of 2000 provides for making of any provision in favour of the Scs and Sts for relaxation in qualifying marks in any examination or lowering the standards of evaluation,
for reservation in matters of promotion to the public services of the center and the states. 3. Special provision in services and educational grants for Anglo-Indians. Before independence, certain posts were reserved for the Anglo-Indians in the railway, customs, postal and telegraph services of the Union.
Similarly, the Anglo-Indian educational institutions were given certain special grants by the center and the states.
Both the benefits were allowed to continue under the Constitution on a progressive diminution basis and finally came to an end in 1960. 4. National commissions for Scs and Sts. The President should set up a national commission for the Scs to investigate all matters relating to the constitutional safeguards for the Scs and to report to him. Article 338. Similarly, the President should also set up a national commission for the Sts to investigate all matters relating to the constitutional safeguards for the Sts and to report to him. Article 338-A. The President should place all such reports before the Parliament, along with the action taken memorandum. Previously, the Constitution provided for a combined National Commission for Scs and Sts. The 89th Amendment Act of 2003 bifurcated the combined commission into two separate bodies. 5. The National Commission for Scs is also required to discharge similar functions with regard to the OBCs and the Anglo-Indian community as it does with respect to the Scs. In other words, the Commission has to investigate all matters relating to the constitutional and other legal safeguards for the OBCs and the Anglo-Indian community and report to the President upon their working. 6.5. Control of the Union over the administration of scheduled areas and the welfare of Sts. The President is required to appoint a commission to report on the administration of the scheduled areas and the welfare of the Sts in the states. He can appoint such a commission at any time but compulsorily after 10 years of the commencement of the Constitution. Hence, a commission was appointed in the year 1960. It was headed by UN Labour and submitted its report in 1961. After 4 decades, the second commission was appointed in 2002 under the chairmanship of Dilip Singh Bhuria. It submitted its report in 2004. Further, the executive power of the centre extends to the giving of directions to a state with respect to the drawing up and execution of schemes for the welfare of the Sts in the state. 6. Appointment of a commission to investigate the conditions of BCs. The President may appoint a commission to investigate the conditions of socially and educationally backward classes and to recommend the steps to improve their condition. The report of the commission is to be placed before the Parliament, along with action taken memorandum. Under the above provision, the President has appointed 2 commissions so far. The first Backward Classes Commission was appointed in 1953 under the chairmanship of Kaka Talunka. It submitted its report in 1955. But no action was taken on it as the recommendations were considered to be too vague and impractical, and also there was a sharp division among the members on the criterion of backwardness. The second Backward Classes Commission was appointed in 1979 with B.P. Mandal as chairman. It submitted its report in 1980. Its recommendations were also lying unattended till 1990 when the V.P. Singh government declared reservation of 27% government jobs for the OBCs. 7. Table 66.1 Articles related to special provisions for certain classes. At a glance, article subject matter number 330 Reservation of seats for scheduled castes and scheduled tribes in the House of the People. 331 Representation of the Anglo-Indian community in the House of the People. 332 Reservation of seats for scheduled castes and scheduled tribes in the legislative assemblies of the states. 333 Representation of the Anglo-Indian community in the legislative assemblies of the states. 334 Reservation of seats and special representation to seats after 70 years. 335 Claims of scheduled castes and scheduled tribes to services and posts. 336 Special provision for Anglo-Indian community in certain services. 337 Special provision with respect to educational grants for the benefit of Anglo-Indian community. 338 National Commission for Scheduled Castes 338 A National Commission for Scheduled Tribes 339 Control of the Union over the administration of scheduled areas and the welfare of scheduled tribes 340 Appointment of a commission to investigate the conditions of backward classes 341 Scheduled Castes 342 Scheduled Tribes Notes and References 1. These are the Constitution, Scheduled Castes, Order, 1950, the Constitution, Scheduled Castes, Union Territories, Order, 1951, the Constitution, Scheduled Tribes, Order, 1950, the Constitution, Scheduled Tribes, Union Territories, Order, 1951 and so on. The Parliament modified the presidential orders by enacting the Scheduled Castes and Scheduled Tribes Orders, Amendment, Act in 1956, in 1976 and in the
subsequent years.
2. The Constitution has used various expressions like socially and educationally backward classes of citizens in Article 15, backward class of citizens in Article 16, weaker sections of the people, in Article 46 and again, socially and educationally backward classes in Article 340. 3. The 8th Amendment Act of 1959 extended the period of 10 years to 20 years, the 23 RD Amendment Act of 1969 to 30 years, the 45th Amendment Act of 1980 to 40 years, the 62 ND Amendment Act of 1989 to 50 years, the 79th Amendment Act of 1999 to 60 years and the 95th Amendment Act of 2009 to 70 years, that is, until the year 2020. 3. This information is downloaded from the website of the Ministry of Law and Justice, Legislative Department. 4. MP Jain, Indian Constitutional Law, Wadhwa, 4th edition, p. 756. 5. For complete details in this regard, see chapters 46 and 47. 6. Even after the 89th Amendment Act of 2003, this provision of Article 338 reads as follows: in this article, reference to the scheduled castes shall be construed as including references to such other backward classes as the President may, on receipt of the report of a commission appointed under Clause 1 of Article 340 by order specify, and also to the Anglo-Indian community. 7. For complete details in this regard, see Mandal Commission and Aftermath, in Chapter 7.
Part X Political Dynamics 67.
Political Parties 68. Elections 69. Voting Behavior 70. Election Laws 71. Electoral Reforms 72. Anti-Defection Law 73. Pressure Groups 74. National Integration 75. Foreign Policy.
Political parties meaning and types.
Political parties are voluntary associations or organized groups of individuals who share the same political views and who try to gain political power through constitutional means and who desire to work for promoting the national interest. There are 4 types of political parties in the modern democratic states, viz. I. Reactionary parties which cling to the old socio-economic and political institutions. 2.
Conservative parties which believe in the status quo.
3. Liberal parties which aim at reforming the existing institutions. And 4. Radical parties which aim at establishing a new order by overthrowing the existing institutions. In their classification of political parties on the basis of ideologies, the political scientists have placed the radical parties on the left and the liberal parties in the center and reactionary and conservative parties on the right. In other words, they are described as the leftist parties, centrist parties and the rightist parties. In India, the CPI and CPM are the examples of leftist parties, the Congress of centrist parties and the BJP is an example of rightist parties. There are 3 kinds of party systems in the world, viz. I. One-party system in which only one ruling party exists and no opposition is permitted, as for example, in the former communist countries like the USSR and other East European countries. 2. Two-party system in which 2 major parties exists, as for example, in USA and Britain 1, and 3, multi-party system in
which there are a number of political parties leading to the formation of coalition governments,
as for example, in France, Switzerland and Italy. Party system in India. The Indian party system has the following characteristic features: multi-party system, the continental size of the country, the diversified character of Indian society, the adoption of universal adult franchise, the peculiar type of political process, and other factors have given rise to a large number of political parties. In fact, India has the largest number of political parties in the world. On the eve of 16th Lok Sabha general elections, 2014, there were 6 national parties, 47 states parties and 1,593 registered unrecognized parties in the country too. Further, India has all categories of parties: left parties, centrist parties, right parties, communal parties, non-communal parties and so on. Consequently, the Han parliaments, Han assemblies and coalition governments have become a common phenomena. One dominant party system. In spite of the multi-party system, the political scene in India was dominated for a long period by the Congress. Hence, Rajni Kothari, an eminent political analyst, preferred to call the Indian party system as one-party dominance system, or the Congress system 3. The dominant position enjoyed by the Congress has been declining since 1967 with the rise of regional parties and other national parties like Janata, 1977, Janata Dal, 1989, and the BJP, 1991, leading to the development of a competitive multi-party system. Lack of clear ideology. Except the BJP and the 2 communist parties, CPI and CPM, all other parties do not have a clear-cut ideology. They, i.e., all other parties, are ideologically closer to each other. They have a close resemblance in their policies and programs. Almost every party advocates democracy,
secularism, socialism and Gandhism.
More than this, every party, including the so-called ideological parties, is guided by only one consideration: power capture. Thus, politics has become issue-based rather than the ideology, and pragmatism has replaced the commitment to the principles.
Personality cult. Quite often,
the parties are organized around an eminent leader who becomes more important than the party and its ideology. Parties are known by their leaders rather than by their manifesto. It is a fact that the popularity of the Congress was mainly due to the leadership of Nehru, Indira Gandhi and Rajiv Gandhi. Similarly, the AIADMK in Tamil Nadu and TDP in Andhra Pradesh got identified with M.G. Ramachandran and N.T. Rama Rao respectively. Interestingly, several parties bear the name of their leader like Biju Janata Dal, Lok Dal, A, Congress, I, and so on. Hence, it is said that there are political personalities rather than political parties in India. Based on traditional factors in the Western countries, the political parties are formed on the basis of socio-economic and political program. On the other hand, a large number of parties in India are formed on the basis of religion, caste, language, culture, race and so on. For example, Shiv Sena, Muslim League, Hindu Mahasabha, Akali Dal, Muslim Majlis, Bahujan Samaj Party, Republican Party of India, Gorkha League and so on. These parties work for the promotion of communal and sectional interests and thereby undermine the general public interest. Emergence of regional parties. Another significant feature of the Indian party system is the emergence of a large number of regional parties and their growing role. They have become the ruling parties in various states like BJD in Orissa, DMK or AIADMK in Tamil Nadu, Akali Dal in Punjab, AGP in Assam, National Conference in J&K, JD-U, in Bihar and so on. In the beginning, they were confined to the regional politics only. But, of late, they have come to play a significant role
in the national politics
due to coalition governments at the center. In the 1984 elections, the TDP emerged as the largest opposition party in the Lok Sabha. Factions and defections. Factionalism, defections, splits, mergers, fragmentation, polarization and so on have been an important aspect of the functioning of political parties in India. Lust for power and material considerations have made the politicians to leave their party and join another party or start a new party. The practice of defections gained greater currency after the fourth general elections, 1967. This phenomenon caused political instability both at the center and in the states and led to disintegration of the parties. Thus, there are 2 Janata Dals, 2 TDPs, 2 DMKs, 2 Communist parties, 2 Congress, 3 Akali Dals, 3 Muslim leagues and so on. Lack of effective opposition. An effective opposition is very essential for the successful operation of the parliamentary democracy prevalent in India. It checks the autocratic tendencies of the ruling party and provides an alternative government. However, in the last 50 years, an effective, strong, organized and viable national opposition could never emerge except in flashes. The opposition parties have no unity and very often adopt mutually conflicting positions with respect to the ruling party. They have failed to play a constructive role in the functioning of the body politic and in the process of nation building. Recognition of national and state parties. The Election Commission registers political parties for the purpose of elections and grants them recognition as national or state parties on the basis of their poll performance. The other parties are simply declared as registered unrecognized parties. The recognition granted by the Commission to the parties determines their right to certain privileges like allocation of the party symbols, provision of time for political broadcasts on the state-owned television and radio stations, and access to electoral rolls. Further, the recognized parties need only one proposer for filing the nomination. Also, these parties are allowed to have 40 star campaigners during the time of elections and the registered unrecognized parties are allowed to have 20 star campaigners. The travel expenses of these star campaigners are not included in the election expenditure of the candidates of their parties. Every national party is allotted a symbol exclusively reserved for its use throughout the country. Similarly, every state party is allotted a symbol exclusively reserved for its use in the state or states in which it is so recognized. A registered and recognized party, on the other hand, can select a symbol from a list of free symbols. In other words, the Commission specifies certain symbols as reserved symbols which are meant for the candidates set up by the recognized parties and others as free symbols which are meant for other candidates. Conditions for recognition as a national party. At present, 2016, a party is recognized as a national party if any of the following conditions is fulfilled for: 1. If it secures 6% of valid votes polled in any 4 or more states at a general election to the Lok Sabha or to the Legislative Assembly, and, in addition, it wins 4 seats in the Lok Sabha from any state or states, or 2. If it wins 2% of seats in the Lok Sabha at a general election, and these candidates are elected from 3 states, or 3. If it is recognized as a state party in 4 states. Conditions for recognition as a state party. At present, 2016, a party is recognized as a state party in a state if any of the following conditions is fulfilled. 5. 1. If it secures 6% of the valid votes polled in the state at a general election to the Legislative Assembly of the state concerned, and, in addition, it wins 2 seats in the Assembly of the state concerned, or 2. If it secures 6% of the valid votes polled in the state at a general election to the Lok Sabha from the state concerned, and, in addition, it wins 1 seat in the Lok Sabha from the state concerned, or 3. If it wins 3% of seats in the Legislative Assembly at a general election to the Legislative Assembly of the state concerned, or 3 seats in the Assembly, whichever is more, or 4. If it wins 1 seat in the Lok Sabha for every 25 seats or any fraction thereof allotted to the state at a general election to the Lok Sabha from the state concerned, or 5. If it secures 8% of the total valid votes polled in the state at a general election to the Lok Sabha from the state or to the Legislative Assembly of the state. This condition was added in 2011. The number of recognized parties keeps on changing on the basis of their performance in the general elections. On the eve of the 16th Lok Sabha general elections, 2014, there were 6 national parties, 47 state parties and 1,593 registered and recognized parties in the country. 6. The national parties and state parties are also known as All India parties and regional parties respectively. Table 67.1 Recognized national parties and state parties, 1st to 16th general elections, year, number of national parties, number of state parties. 1st, 1952, 1439. 2nd, 1957, 411. 3rd, 1962, 611. 4th, 1967, 714. 5th, 1971, 817. 6th, 1977, 515. 7th, 1980, 619. 8th, 1984, 719. 9th, 1989, 820. 10th, 1991, 928. 11th, 1996, 830. 12th, 1998, 730. 13th, 1999, 740. 14th, 2004, 636. 15th, 2009, 740. 16th, 2014, 647. Table 67.2 Recognized national parties and their symbols, 2016, SL.No. Name of the party, abbreviation, symbol reserved 1. Bahujan Samaj Party, BSP, Elephant * 2. Bharatiya Janata Party, BJP, Lotus 3. Communist Party of India, CPI, Ears of Corn and Sickle 4. Communist Party of India, Marxist, CPM, Hammer, Sickle and Star 5. Indian National Congress, INC, Hand 6. Nationalist Congress Party, NCP, Clock 7. All India Trinamool Congress Flowers and Grass, AITC, * in all states U.T.S except in Assam, where its candidates will have to choose a symbol out of the list of free symbols specified by the Election Commission. Table 67.3 Recognized state parties and their symbols, 2016, name of the SL.No.
State Union Territory name of the
state party, abbreviation, symbol reserved 1. Andhra Pradesh 1. Telugu Desam, TDP, Bicycle 2. Yujan Shramika Ritu Congress Party, YSRCP, Ceiling Fan 2. Arunachal Pradesh People's Party of Arunachal, PPA, Maj 3. Assam 1. All India United Democratic Front, AUDF, Lock and Key 2. Assam Gun Parishad, AGP, Elephant 3. Bodoland People's Front, BPF, Nangol 4. Bihar 1. Janata Dal, United, JD, U, Arrow 2. Lok Jan Shakti Party, LJSP, Bungalow 3. Rashtriya Janata Dal, RJD, Hurricane Lamp 4. Rashtriya Lok Samta Party, RLSP, Ceiling Fan 5. Goa Maharashtravadi Gomantak, MAG, Lion 6. Haryana 1. Haryana Janhit Congress, BL, HJC, BL, Tractor 2. Indian National Lok Dal, INLD, Spectacles 7. Jammu and Kashmir 1. Jammu and Kashmir National Conference, JKNC, Plough 2. Jammu and Kashmir National Panthers Party, JKNPP, Bicycle. 3 Jammu and Kashmir People's in Pot and Pen Democratic Party, JKPDP, 8. Jharkhand 1. All Jharkhand Students Union, RGSU, Banana 2. Jharkhand Mukti Morcha, JMM, Bow and Arrow 3. Jharkhand Vikas Morcha, Prajtantrik, JVM, P, Comb 4. Rashtriya Janata Dal, RJD, Hurricane Lamp 9. Karnataka Janata Dal, Secular, JD, S, a lady farmer carrying paddy on her head 10. Kerala 1. Janata Dal, Secular, JD, S, a lady farmer carrying paddy on her head 2. Kerala Congress, M, KEC, M, 2 leaves 3. Indian Union Muslim League, IUML, ladder 4. Revolutionary Socialist Party, RSP, Spade and Stoker 11. Maharashtra 1. Maharashtra Navnirman Sena, MNS, Railway Engine 2. Shiv Sena, SHS, Bow and Arrow 12. Manipur 1. Naga People's Front, NPF, Cock 2. People's Democratic Alliance, PDA, Crown 13. Meghalaya 1. United Democratic Party Drum.
UDP 2.
Hill State People's Democratic Party, HSPDP, Lion 3. National People's Party, NPP, Book 14. Mizoram 1. Mizo National Front, MNF, Star 2. Mizoram People's Conference, MPC, Electric Bulb 3. Zoram Nationalist Party, ZNP, Sun, without race, 15. Nagaland Naga People's Front, NPF, Cock 16. NCT of Delhi Aam Aadmi Party, AAP, Broom 17. Odisha Biju Janata Dal, BJD, Conch 18. Puducherry 1. All India Anna Dravida Munnetra Kazhagam, ADMK, or AIADMK, 2 leaves 2. All India NR Congress, Engak, Jug 3. Dravida Munnetra Kazhagam, DMK, Rising Sun 4. Patali Makal Kachi, PMK, Mango 19. Punjab 1. Shiromni Akali Dal, SAD, Scales 2. Aam Aadmi Party, AAP, Broom 20. Sikkim 1. Sikkim Democratic Front, SDF, Umbrella 2. Sikkim Krantikari Morcha, SKM, Table Lamp. 21 Tamil Nadu 1. All India Anna Dravida Munnetra Kazhagam, ADMK, or AIADMK, 2 leaves 2. Dravida Munnetra Kazhagam, DMK, Rising Sun 3. Disya Mokoku Dravida Kazhagam, DMDK, Nagra 22. Telangana 1. All India Majlisi Ittihadul Muslimin, AMIM, Kite 2. Telangana Rashtra Samiti, TRS, Car 3. Telugu Desam, TDP, Bicycle 4. Yuvan Shramika Ritu Congress Party, YSRCP, Ceiling Fan 23. Uttar Pradesh 1. Rashtriya Lok Dal, RLD, Hand Pump 2. Samajwadi Party, SP, Bicycle 24. West Bengal 1. All India Forward Bloc, AIFB, Lion 2. Revolutionary Socialist Party, RSP, Spade and Stoker Table 67.4 Formation of Political Parties, Chronological Order, SL No. Name of the party, Abbreviation, Year of Formation 1. Indian National Congress, INC, 1885 2. Shiromni Akali Dal, SAD, 1923. Communist Party of India, CPI, 1925 Jammu and Kashmir National Conference. 4. JKNC, 1939-5. All India Forward Bloc, AIFB, 1939-6. Revolutionary Socialist Party, RSP, 1947. Indian Union Muslim League, IUML, 1948-8. Dravida Munnetra Kazhagam, DMK, 1949-9. Mizo National Front, MNF, 1961-10. Maharashtravadi Gomantak Party, MAG, 1963-11. Communist Party of India, Marxist, CPM, 1964-12. Shiv Sena, SHS, 1966-13. Mizoram People's Conference, MPC, 1972-14. Jharkhand Mukti Morcha, JMM, 1972-15. All India Anna Dravida Munnetra Kazhagam, AIADMK, 1972-16. Kerala Congress, M, KEC, M, 1979-17. Bharatiya Janata Party, BJP, 1980-18. Telugu Desam Party, TDP, 1982-19. Bahujan Samaj Party, BSP, 1984-20. Assam Gun Parishad, AGP, 1985-21. People's Party of Arunachal, PPA, 1987-22. Samajwadi Party, SP, 1992-23. Sikkim Democratic Front, SDF, 1993-24. Rashtriya Lok Dal, RLD, 1996-25. Zoram Nationalist Party, ZNP, 1997-26. Rashtriya Janata Dal, RJD, 1997. 27 Biju Janata Dal, BJD, 1997-28. All India Trinamool Congress, AITC, 1998-29. Indian National Lok Dal, INLD, 1998-30. Jammu and Kashmir People's Democratic Party, PDP, 1999-31. Janata Dal, United, JD, U, 1999-32. Janata Dal, Secular, JD, S, 1999-33. Nationalist Congress Party, NCP, 1999-34. Lok Janshakti Party, LJSP, 2035. Telangana Rashtra Samiti, TRS, 2001-36. Naga People's Front, NPF, 2002-37. All India United Democratic Front, AUDF, 2004-38. Disya Mopoku Dravidar Kazhagam, DMDK, 2005-39. Maharashtra Navnirman Sena, MNS, 2006-40. Jharkhand Vikas Morcha, Prajtantrik, JVMP, 2006-41. Haryana Janhit Congress, BL, HJCBL, 2007-42. Yuvan Shramika Ritu Congress Party, YSRCP, 2011-43. All India NR Congress, Engak, 2011-44. Aam Aadmi Party, AAP, 2012-45. National People's Party, NPP, 2013-46. Rashtriya Lok Samta Party, RLSP, 2013-47. Sikkim Krantikari Morcha, SKM, 2013. Note, adopted from J.C. Johari, Indian Government and Politics, Vishal, 13th edition, 2001, p. 607. Notes and references 1. The two parties in the US are Democratic and Republican, and in Britain are Conservative and Labour. 2. India votes the general elections 2014, the Election Commission of India, p.1. 3. Rajni Kothare, Congress System in India, Asian Survey, Volume 4, Number 12, December, 1964, pp. 118. 4. The Election Symbols, Reservation and Allotment, Order, 1968, as amended from time to time. The latest amendment to this order was made in 2011. 5. Ibid. 6. See reference to above. Elections Electoral System Articles 324 to 329 in Part 15 of the Constitution make the following provisions with regard to the electoral system in our country. 1. The Constitution, Article 324, provides for an independent election commission in order to ensure free and fair elections in the country. The power of superintendence, direction and conduct of elections to the Parliament, the state legislatures, the office of the President and the office of the Vice President is vested in the Commission 1. At present, the Commission consists of a Chief Election Commissioner and 2 Election Commissioners 2. 2. There is to be only one general electoral roll for every territorial constituency for election to the Parliament and the state legislatures. Thus, the Constitution has abolished the system of communal representation and separate electorates which led to the partition of the country. 3. No person is to be ineligible for inclusion in the electoral roll on grounds only of religion, race, caste, sex or any of them. Further, no person can claim to be included in any special electoral roll for any constituency on grounds only of religion, race, caste or sex or any of them. Thus, the Constitution has accorded equality to every citizen in the matter of electoral franchise. For the elections to the Lok Sabha and the state assemblies are to be on the basis of adult franchise. Thus, every person who is a citizen of India and who is 183 years of age, is entitled to vote at the election provided he is not disqualified under the provisions of the Constitution or any law made by the appropriate legislature, parliament or state legislature, on the ground of non-residence, unsound mind, crime or corrupt or illegal practice. 5. Parliament may make provision with respect to all matters relating to elections to the Parliament and the state legislatures, including the preparation of electoral rolls, the delimitation of constituencies and all other matters necessary for securing their due constitution. 6. The state legislatures can also make provision with respect to all matters relating to elections to the state legislatures, including the preparation of electoral rolls and all other matters necessary for securing their due constitution. But they can make provision for only those matters which are not covered by the Parliament. In other words, they can only supplement the parliamentary law and cannot override it. 7. The Constitution declares that the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies cannot be questioned in any court. Consequently, the orders issued by the Delimitation Commission become final and cannot be challenged in any court. 8. The Constitution lays down that no election to the Parliament or the state legislature is to be questioned except by an election petition presented to such authority and in such manner as provided by the appropriate legislature. Since 1966, the election petitions are treatable by high courts alone. But the appellate jurisdiction lies with the Supreme Court alone. Article 323b empowers the appropriate legislature, Parliament or state legislature, to establish a tribunal for the adjudication of election disputes. It also provides for the exclusion of the jurisdiction of all courts, except the special leave appeal jurisdiction of the Supreme Court, in such disputes. So far, no such tribunal has been established. It must be noted here that in Chandra Kumar Case 5, 1997, the Supreme Court declared this provision as unconstitutional. Consequently, if at any time an election tribunal is established, an appeal from its decision lies to the High Court. Election Machinery Election Commission of India, ECI, under Article 324 of the Constitution of India, the Election Commission of India is vested with the power of superintendence, direction and control of conducting the elections to the Lok Sabha and state legislative assemblies. The Election Commission of India is a three-member body, with one Chief Election Commissioner and two Election Commissioners. The President of India appoints the Chief Election Commissioner and the Election Commissioners. Chief Electoral Officer, CEO, the Chief Electoral Officer of a State Union Territory is authorized to supervise the election work in the State Union Territory subject to the overall superintendence, direction and control of the Election Commission. The Election Commission of India nominates or designates an officer of the government of the State Union Territory as the Chief Electoral Officer in consultation with that State Government Union Territory Administration. District Election Officer, DO, subject to the superintendence, direction and control of the Chief Electoral Officer. The District Election Officer supervises the election work of a district. The Election Commission of India nominates or designates an officer of the state government as the District Election Officer in consultation with the state government. Returning Officer, RO, the returning officer of a parliamentary or assembly constituency is responsible for the conduct of elections in the parliamentary or assembly constituency concerned. The Election Commission of India nominates or designates an officer of the government or a local authority as the returning officer for each of the assembly and parliamentary constituencies in consultation with the state government union territory administration. In addition, The Election Commission of India also appoints one or more assistant returning officers for each of the assembly and parliamentary constituencies to assist the returning officer in the performance of his functions in connection with the conduct of elections. Electoral Registration Officer, ERO. The Electoral Registration Officer is responsible for the preparation of electoral rolls for a parliamentary assembly constituency. The Election Commission of India, in consultation with the state UT government, appoints an officer of the government or the local authorities as the Electoral Registration Officer. In addition, the Election Commission of India also appoints one or more assistant electoral registration officers to assist the Electoral Registration Officer in the performance of his functions in the matter of preparation revision of electoral rolls. Presiding officer. The presiding officer with the assistance of polling officers conducts the poll at a polling station. The district election officer appoints the presiding officers and the polling officers. In the case of union territories, such appointments are made by the returning officers. Observers. The Election Commission of India nominates officers of government as observers for parliamentary and assembly constituencies. These observers are of various kinds. 6. 1. General observers. The Commission deploys general observers in adequate number to ensure smooth conduct of elections. These observers are asked to keep a close watch on every stage of the electoral process to ensure free and fair elections. 2. Expenditure observers. Expenditure observers from central government services are appointed to keep a close watch on election expenditure of the candidates and to ensure that no inducement is offered to the electors during the entire election process for exercise of their franchise. 3. Police observers. The Commission deploys IPS officers as police observers at state and district levels, depending upon the sensitivity of the constituency, wherever required. They monitors all activities relating to force deployment, law and order situation and coordinate between the civil and police administration to ensure free and fair election. 4. Awareness observers. For the first time in the 16th Lok Sabha elections, 2014, the Commission deployed central awareness observers to oversee the efficient and effective management of the electoral process at the field level, mainly in respect of voter awareness and facilitation. Awareness observers are deployed to observe the interventions undertaken by the election machinery to bridge the gap in people's participation in the electoral process, particularly in regard to voters' turnout. They also monitors the various media-related aspects of RP Act 1951 and observe the mechanism directed by the Commission at district levels on checking the problem of paid news. 5. Micro observers. In addition to general observers, the Commission also deploys micro-observers to observe the poll proceedings on the poll day in selected critical polling stations. They are chosen from central government central PSUs officials. Micro-observers verify the BMF at the polling stations and certify the same before start of polling. They observe the proceedings at the polling stations on the poll day right from the mock poll to the completion of poll and the process of sealing of EVMs and other documents to ensure that all instructions of the Commission are complied with by the polling parties and the polling agents. They also report to the general observers directly about vitiation of the poll proceedings, if any, in their allotted polling stations. 6. Assistant expenditure observers. In addition to expenditure observers, assistant expenditure observers are appointed for each assembly segment to ensure that all major election campaign events are videographed and complaints of electoral malpractices are promptly attended. Election process. 7. Time of elections. Elections for the Lok Sabha and every state legislative assembly have to take place every 5 years, unless called earlier. The President can dissolve Lok Sabha and call a general election before 5 years is up, if the government can no longer command the confidence of the Lok Sabha, and if there is no alternative government available to take over. Schedule of elections. When the 5-year limit is up, or the legislature has been dissolved and new elections have been called, the Election Commission puts into effect the machinery for holding an election. The Constitution states that there can be no longer than 6 months between the last session of the dissolved Lok Sabha and the recalling of the new house, so elections have to be concluded before then. The Commission normally announces the schedule of elections in a major press conference a few weeks before the formal process is set in motion. The Model Code of Conduct for Guidance of Candidates and Political Parties comes immediately into effect after such announcement date. The formal process for the elections starts with the notification or notifications calling upon the electorate to elect members of a house. As soon as notifications are issued, candidates can start filing their nominations in the constituencies from where they wish to contest. These are scrutinized by the returning officer of the constituency concerned after the last date for the same is over after about a week. The validly nominated candidates can withdraw from the contest within 2 days from the date of scrutiny. Contesting candidates get at least 2 weeks for political campaign before the actual date of poll. On account of the vast magnitude of operations and the massive size of the electorate, polling is held on a number of days for the national elections. A separate date for counting is fixed and the results declared for each constituency by the concerned returning officer. The Commission compiles the complete list of members elected and issues an appropriate notification for the due constitution of the House. With this, the process of elections is complete and the President, in case of the Lok Sabha, and the governors of the concerned states, in case of state assemblies, can then convene their respective houses to hold their sessions. Oath or affirmation. It is necessary for a candidate to make and subscribe an oath or affirmation before an officer authorized by the Election Commission. 9. For any particular election, the authorized persons are, principally, the returning officer and the assistant returning officer for the constituency. In the case of a candidate confined in a prison or under preventive detention, the superintendent of the prison or commandant of the detention camp in which he is so confined or is under such detention is authorized to administer the oath. And in the case of a candidate confined to bed in a hospital or elsewhere owing to illness or any other cause, the medical superintendent in charge of the hospital or the medical practitioner attending on him is similarly authorized. If a candidate is outside India, the Indian ambassador or high commissioner or diplomatic consular authorized by him can also administer oath affirmation. The candidate, in person, is required to make the oath or affirmation immediately after presenting his nomination papers and in any case not later than the day previous to the date of the scrutiny. 10. Election campaign. The campaign is the period when the political parties put forward their candidates and arguments with which they hope to persuade people to vote for their candidates and parties. Candidates are given a week to put forward their nominations. These are scrutinized by the returning officers and if not found to be in order can be rejected after a summary hearing. Validly nominated candidates can withdraw within 2 days after nominations have been scrutinized. The official campaign lasts at least 2 weeks from the drawing up of the list of nominated candidates, and officially ends 48 hours before polling closes. During the election campaign, the political parties and contesting candidates are expected to abide by a model code of conduct evolved by the Election Commission on the basis of a consensus among political parties. The model code lays down broad guidelines as to how the political parties and candidates should conduct themselves during the election campaign. It is intended to maintain the election campaign on healthy lines, avoid clashes and conflicts between political parties or their supporters and to ensure peace and order during the campaign period and thereafter, until the results are declared. The model code also prescribes guidelines for the ruling party either at the center or in the state to ensure that a level field is maintained and that no cause is given for any complaint that the ruling party has used its official position for the purposes of its election campaign. 11. Once an election has been called, parties issue manifestos detailing the programs they wish to implement if elected to government, the strengths of their leaders, and the failures of opposing parties and their leaders. Slogans are used to popularize and identify parties and issues, and pamphlets and posters distributed to the electorate. Rallies and meetings where the candidates try to persuade, cajole and enthuse supporters, and denigrate opponents, are held throughout the constituencies. Personal appeals and promises of reform are made, with candidates traveling the length and breadth of the constituency to try to influence as many potential supporters as possible. Polling days. Polling is normally held on a number of different days in different constituencies, to enable the security forces and those monitoring the election to keep law and order and ensure that voting during the election is fair. Ballot papers and symbols. After nomination of candidates is complete, a list of competing candidates is prepared by the returning officer, and ballot papers are printed. Ballot papers are printed with the names of the candidates, in languages set by the Election Commission, and the symbols allotted to each of the candidates. Candidates of recognized parties are allotted their party symbols. Voting procedure. Voting is by secret ballot. Polling stations are usually set up in public institutions, such as schools and community halls. To enable as many electors as possible to vote, the officials of the Election Commission try to ensure that there is a polling station within 2 kilometers of every voter, and that no polling stations should have to deal with more than 1,500 voters. Each polling station is open for at least 8 hours on the day of the election. On entering the polling station, the elector is checked against the electoral roll 12, and allocated a ballot paper. The elector votes by marking the ballot paper with a rubber stamp on or near the symbol of the candidate of his choice, inside a screened compartment in the polling station. The voter then folds the ballot paper and inserts it in a common ballot box, which is kept in full view of the presiding officer and polling agents of the candidates. This marking system eliminates the possibility of ballot papers being surreptitiously taken out of the polling station or not being put in the ballot box. Since 1998, the Commission has increasingly used electronic voting machines, EMVs, instead of ballot boxes. In 2003, all state elections and by-elections were held using EVMs. Encouraged by this, the Commission took a historic decision to use only EVMs for the Lok Sabha election in 2004. More than 1 million EVMs were used in this election. Electronic voting machine. An electronic voting machine, EVM, is a simple electronic device used to record votes in place of ballot papers and boxes which were used earlier in conventional voting system. The advantages of the EVM over the traditional ballot paper ballot box system are given here. It eliminates the possibility of invalid and doubtful votes which, in many cases, are the root causes of controversies and election petitions. 2. It makes the process of counting of votes much faster than the conventional system. 3. It reduces to a great extent the quantity of paper used, thus saving a large number of trees, making the process eco-friendly. 4. It reduces cost of printing, almost nil, as only one sheet of ballot paper is required for each polling station. 13. Supervising elections. The Election Commission appoints a large number of observers to ensure that the campaign is conducted fairly, and that people are free to vote as they choose. Election expenditure. Observers keeps a check on the amount that each candidate and party spends on the election. Counting of votes. After the polling has finished, the votes are counted under the supervision of returning officers and observers appointed by the Election Commission. After the counting of votes is over, the returning officer declares the name of the candidate, to whom the largest number of votes have been given, as the winner and as having been returned by the constituency to the concerned house. Elections to the Lok Sabha are carried out using a first-past-the-post electoral system. The country is split up into separate geographical areas, known as constituencies, and the electors can cast one vote each for a candidate, the winner being the candidate who gets the maximum votes. Elections to the state assemblies are carried out in the same manner as for the Lok Sabha election, with the states and union territories divided into single-member constituencies, and the first-past-the-post electoral system. Used. Media coverage. In order to bring as much transparency as possible to the electoral process, the media are encouraged and provided with facilities to cover the election, although subject to maintaining the secrecy of the vote. Media persons are given special passes to enter polling stations to cover the poll process and the counting halls during the actual counting of votes. Election petitions. Any elector or candidate can file an election petition if he or she thinks there has been malpractice during the election. An election petition is not an ordinary civil suit, but treated as a contest in which the whole constituency is involved. Election petitions are tried by the High Court of the state involved, and if upheld can even lead to the restaging of the election in that constituency. Table 68.1 Results of Lok Sabha elections. General elections. Year. Elective seats. Seats won by parties. Major. First. 1952. 489 Congress 364. Communist 16. Socialist 12. KMPP 9. Jana Sun 3. Second. 1957. 494 Congress 371. Communist 27. Praja Socialist 19. Jana Sun 4. Third. 1962. 494 Congress 361. Communist 29. Swatantra 18. Jana Sun 14. Praja Socialist 12. Socialists 6. Fourth. 1967. 520 Congress 283. Swatantra 44. Jana Sun 35. CPI 23. CPM 19. Sanyukta Socialist 23. Praja Socialist 13. Fifth. 1971. 518 Congress 352. CPM 25. CPI 24. DMK 23. Jana Sun 21. Swatantra 7. Socialist 5. Sixth. 542 Janata 298. Congress 154. CPM 22. CPI 7. 1977. AIADMK 18. Seventh. 1980. 542 Congress 353. Janata. Secular. 41. Janata 31. CPM 36. CPI 11. DMK 16. 8. 1984. 542 Congress 415. TDP 28. CPM 22. CPI 6. Janata 10. AIADMK 12. BJP 2. 9th. 1989. 543 Congress 197. Janata Dal 141. BJP 86. CPM 32. CPI 12. AIADMK 11. TDP 2. 10th. 1991. 543 Congress 232. BJP 119. Janata Dal 59. CPM 35. CPI 13. TDP 13. AIADMK 11. 11th. 1996. 543 BJP 161. Congress 140. Janata Dal 46. CPM 32. TMCM 20. DMK 17. SP 17. TDP 16. SS 15. CPI 12. BSP 11. 12th. 1998. 543 BJP 182. Congress 141. CPM 32. AIADMK 18. TDP 12. SP 20. Samatha 12. RJD 17. 13th. 1999. 543 BJP 182. Congress 114. CPM 33. TDP 29. SP 26. JD. U. 20. SS 15. BSP 14. DMK 12. BJD 10. AIADMK 10. 14th. 2004. 543 Congress 145. BJP 138. CPM 43. SP 36. RJD 24. BSP 19. DMK 16. Shiv Sena 12. BJD 11. CPI 10. 15th. 2009. 543 Congress 206. BJP 116. SP 23. BSP 21. JD. U. 20. Trinamool 19. DMK 18. CPM 16. BJD 14. Shiv Sena 11. NCP 9. AIADMK 9. TDP 6. RLD 5. CPI 4. RJD 4. SAD 4. BJP 282, Congress 44, AIADMK 37, Trinamool 16, 543 34, BJD 20, Shiv Sena 18, TDP 16, TRS 11, CPM 2014, 9, YSR Congress 9, NCP 6, LJP 6, SP 5, ARP 4, RJD 4, SAD 4. Table 68.2 Prime Ministers after each Lok Sabha General Elections National Party's Prime Minister. Year. First. 1952 asterisk. BJS, BPI, CPI, FBL, MG, FBL, RG, HMS, INC, KLP, KMPP, RCPI, RRP, RSP, SCF, SP Jawaharlal Nehru, 15 August 1947 to 27 May 1964, 2nd, 1957, BJS, CPI, INC, PSP do 3rd, 1962, CPI, INC, BJS, PSP, SSP, SWA do Gulzari Lal Nanda, 27th May 1964 to 9th June, 1964, Lal Bahadur Shastri, 9th June 1964 to 11th January 1966, Gulzari Lal Nanda, 11th